Kilpatrick. And is Kilpatrick something we could resolve today?
Yes, sir. I'm glad to involve it.
Judge, I'll reach out to them and see if we can get them on Zoom.
I just sent you Teams to that effect. Thank you. I want my words back now. All right. Ms. Rivers, good morning. My computer says my microphone's not working, but I don't really talk through the computer. Are you able to hear me?
Yes, I can hear you loud and clear. Good morning.
Good morning. Excellent. Then we can press forward despite this error message on the screen. We have a diverse calendar this morning, bunch of different things. I'm gonna call it. We'll figure out who's ready to go and then tackle things as we can. Position 1 is Charlie Daniels. I see his lawyer here in court. I see Mr. Daniels on the Zoom call, and of course, Ms. Smith is here. Still a plea?
Yes, Judge.
And ready to do it?
Yes, Judge.
Okay, great. We will turn to that in a minute. Let me figure out who else is here. Dearius Watkins should be in custody.
And this should be a consent revocation. I just need to speak with him very briefly.
All right. Then Clifton Kilpatrick, we just mentioned, he is in Oconee. Hopefully we get him. Mr. Gamba Mateas will need an interpreter. And that was one that he was so ready to plead. But then we just, I think it was an interpreter situation.
Yeah.
Like it would be difficult to do with people not all in the same place.
The internet wasn't working. It was it's going to be easier with him. Everyone.
Okay, but he's here now? I mean, he'd be in custody. We don't have an interpreter yet. We'll work on that. But Mr. Gamba Mateas, the only person not here is Kilpatrick. Okay, so he's here. So our project is to get an interpreter here.
And an 88 that could handle the case because I don't know.
Well, first of all, Ms. Smith can handle anything. But not her case. Is Ms. Nix's email says she's still in trial, but she's not. She may just still be recovering from the big win down in 1D. Is she planning on being here, Ms. Smith?
I'll reach out to her.
Thank you. Maybe she'll bring an interpreter with her. All right, we'll hold on that. Jamiron Brown, I was told to omit. I'm not sure why.
He already handled his bond hearing at the last court date.
Okay.
So he'll be released soon. I meant to put Deshawn Price, but the wrong case number. So that's the add-on to Deshawn Price.
Oh, got it. Okay. Then we've got Marcus Ware with 2 cases. One is a plea and one is a revocation.
That's correct.
Okay, and those are ready to go? All right. And then we've got as our add-on Deshawn Price, and that is just a bond hearing?
Yes.
Okay, all right. Well, why don't we start with Mr. Daniels and take care of that. That'll allow us to hopefully get the interpreter here. But if we're waiting on the interpreter, we can knock out some of these revocations. There's Mr. Daniels. We'll add the lawyer. And Ms. Smith, you'll come on up here. You got everyone we need. All right. Mr. Majeski, if you could move the monitor a little bit so you are more centered in the monitor. It rotates. You can also just move yourself, but there you go. And now stand back at the podium. Perfect. That means Ms. Rivers can see everyone. Let me send one more Teams alert. All right, let me know when you're ready. You're ready, okay. We're going to get on the record. This is position 1 on our calendar. It's 25 SC 003 256, State versus Charlie Daniels. Mr. Daniels, can you hear us?
Yes, sir.
Great. Are you at work?
Yes, sir.
Are you a fireman? What do you do with that jacket?
I do cement, concrete.
Okay. But you need to wear like reflective gear?
Yes, sir.
Okay, great. Mr. Daniels is reporting from work. Mr. Majeski, his lawyer, is here in court, as is the prosecutor, Ms. Smith. Mr. Daniels, before I hand things over to Ms. Smith for the plea, I need to make sure that you are willing to proceed virtually. You have a right to be here in court, but you can waive that right and appear from wherever you are. Are you willing to do that?
Yes, sir.
You also have a right to have Mr. Majeski by your side so that you could consult with him privately if you needed to. He's in court. You are at work. Are you waiving your right to have your attorney by your side for the plea?
No, sir. You're right there.
Well, he is right there, but he's not right next to you. And I need you to tell me it's okay that he's not right next to me. Is that correct?
Yes, sir. It's okay.
Okay. Now, I want to be clear. If you need to speak with Mr. Majeski at any time privately, he'll just step right outside and give you a call on his phone, and you can say, hey, what's going on with this? And he can give you whatever counsel you need. I don't think that'll come up in this process, but if you have a need to speak with him privately, just tell me that, and we'll pause. You can drop off the call, talk to him, and then hop back on, okay? Last thing, I need you to let me know if at any point you cannot hear us or if at any point you have a question about what's going on so that I can answer that question. Will you do that? Okay, and make sure you speak up. Ms. Smith, you are up.
Thank you. Mr. Daniels, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Charlie Raymond Daniels Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 45 years old, ma'am. I went to the 12th grade, ma'am.
Did you graduate high school or you made it to 12th?
I just made it to the 12th, but I'm online doing GED right now, sir.
Great.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with his services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes, ma'am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
For the purpose of this plea, yes, ma'am.
Mr. Daniels, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years to serve 5 months with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are charged with a crime in the future, that this plea may be used to enhance that sentencing, even in a federal case?
Yes, ma'am.
Are you currently on probation?
Yes, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering this guilty plea today?
Yes, ma'am.
And are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you
Yes,
understand
ma'am.
that those are the, okay. Counsel, are you satisfied your client understands these rights that they'll be waiving by entering this guilty plea?
Yes, ma'am.
Mr. Daniels, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003256, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, battery?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes, ma'am.
Do you understand that that appeal procedure must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay, thank you, Mr. Daniels. Your Honor, if this case were to proceed to trial, the state would show that on February 15th, 2023, officers responded to 3553 Fairburn Place Northwest, that's in Atlanta, Georgia, and also in Fulton County. They were dispatched to the location based on an injured person call. When the officers got there, they spoke with the victim, Ms. Tamala Jones, who stated that a guy she met off of Facebook around 2 weeks prior to the incident attacked her. She stated that the defendant believed that he left his wallet in her car after they spent time together, and the defendant then came back to the victim's home and attacked her in her front yard, causing a knot on her head and swelling. When the officers got there, they followed up with the victim and was able to see the knot that she had on her head. And also the victim in this case advised that the defendant pulled out a silver and black gun and pointed it at her as he struck her with his fist. At this time, the defendant was not apprehended because he left the scene. However, he was eventually picked up on January 3rd, 2024, where he was charged with the offenses we have before us today. Regarding the negotiated plea, and those are the facts of the case, Your Honor. Regarding the negotiated plea between the state and defense, we've agreed to a sentence of 7 years to serve 5 months with the balance probated. For count 1, a sentence of 2 years to serve 5 months. For count 2, 5 years consecutive. And for count 3, 12 months probation. For counts 1 and 2 to run concurrent. Regarding the special conditions of probation, the state is recommending that the defendant have no contact with the victim in this case, to stay away from the incident location, for the defendant to complete an anger management course, also for the defendant to complete 60 hours of community service, for the defendant to be gainfully employed, as he's employed now, so there shouldn't be an issue, for there to be a Fourth Amendment waiver, And lastly, Your Honor, for the defendant to pay the medical bills of the victim, it wasn't stated in the facts, but after this incident happened, the victim reported that she started to have seizures because of the attack that was made on her. Therefore, the state is asking for the defendant in this case to pay the medical bills of the victim. And I believe that there would be a restitution hearing in this case based on those medical bills that can be scheduled at a later time.
Got it.
For right now, that's all from the state, Your Honor.
Okay, thank you. Hi. Are you here from pretrial? Great, you are? Bostic. Hello, Ms. Bostic. Can you share criminal history on Mr. Daniels, please?
Regards to Mr. Daniels, 23 prior arrests, he has 5 felonies, all of the convictions are more than 10 years old. His probation is from 2010 on 10 SC 88293, robbery 2 counts, sentence 10/27/10, 10 years confinement, 10 years probation. 4 other felonies, 1 being an ag assault, 08. The other 2 are for drugs and criminal damage to property. He has an open case in Clayton for firearm during, firearm by, and Schedule 1 from 10/31/24. Nothing further.
And the most recent arrest would be that Clayton arrest?
No, for probation violations. And that was. His last arrest was 12/27/24.
12/24. Okay, thank you so much. Ms. Simpson, I saw some in Odyssey arrests that post-date the arrest for this, and it mentioned probation violation. Has Mr. Daniels already been violated for this conduct? Okay, so he doesn't face exposure here. And how much time remains on the 10 SC case?
He's actually got 2.
Oh, okay.
So he has a 09 SC 82922. He has 4 years remaining on that one.
Yep.
And the 10 SC 88293, he has 3 years, 11 months.
All right. Got it. Thank you. Mr. Majeski.
Yes, Judge, thank you. With the probation revocation and the time that he served before he got out on bond, according to the revised version of 17-10-11, he's done all the time that he needs to do. Mm-hmm. Subsection A, as you're aware, says, incarceration for any reason. Mm-hmm. So we should be good there. Judge, every time I come in here, I tell you about how much I like my client. I realize I've got a history of that over the past decade or so that we've known each other, but maybe it's because
So you've worked with Mr. Daniels throughout some of these things I've heard about?
Yes, Judge. I did
Okay.
the probation revocation. I've had a lot of contact with him. He's one of my guys. He shows up for his appointments. He returns my phone calls, which is rough
That's
currency
refreshing.
these days.
Yeah.
He's got a good job right now. We really appreciate you allowing him to appear via Zoom. Unfortunately, he had a spectacular wife that I worked with. Often I work with the spouse when they're in custody. She died in a freak accident. A brown recluse bite can be fatal.
Wow.
I mean, people talk about black widows like there's something that's just going to make you sick, but she got bit by a brown recluse and died. So he is now dealing with their 5 children by himself, supporting them by himself. He was lucky enough to get this good job. He's got a real good force of will. I mean, this man is he's got some substance. He takes pride in himself, and he's really taking pride in his ability to provide for his family without the support of his wife, which she was amazing, Judge. You would have loved her. She's just one of those people you can't help but really like. I think this is a good resolution of this case, Judge. We were going to try it, but this is something that needed to be worked out based on the criminal history and discrepancies in the facts and everything.
Right.
Ms. Smith has been great to work with. She's a tough prosecutor, a very good lawyer. It often helps when you have somebody like that you can work with to get to this resolution. I urge you to take this negotiated, Judge, all the work that's gone into this case and everything. I really think this is the appropriate result here, given this all the circumstances.
Got it. Okay. Mr. Daniels, first, I'm sorry to hear about what happened to your wife. That is tragic. Was it something where at least she was given medical care, but it didn't work out, or she didn't even make it to a hospital?
I was incarcerated at the time, so I didn't really have contact at the time. because with Jackson, they don't have phones.
So that makes it even harder. You weren't there to help. I'm sorry to hear that. How old is your oldest kid?
My oldest kid, like 27,
And how old is your youngest kid?
like 1 year old.
1 year old. Okay. So you got some still in the house.
Yes, sir.
Okay. All right. When did your wife pass?
Last year in June? Last year in June.
Okay. So you were serving your revocation time when this happened.
Yes, sir.
Okay. This case in Clayton, Mr. Majeski, are you handling that for Mr. Daniels?
Not yet. I imagine we'll probably get that tied up for him now.
Okay. What do you know about the case in Clayton, Mr. Daniels? I'm not asking about the facts. Don't tell me you did it or you didn't do it, but what are you charged with? Is it indicted yet? Have you gone to court?
I haven't went to court, and the case up there is like, it's beatable, but it's just like I didn't have no knowledge of something that was in the car. But
All right. I told you not to get into that kind of stuff, but is it just gun or is it gun and drugs?
I think it's just done.
Okay. All right. Well, you should know, and I know you know it, but I'm going to tell you anyway. You can't have a gun. You can't be around guns. You can't be in a car that has guns in it. You can't be in a house that has guns in it. So if your household has guns in the household, they may belong to your older children. They need to get out of the house. They need to not be in cars you're in. I don't know why you didn't get charged with felon in possession as well. The state should have charged you with another felony. And I'm not encouraging them to do that. We're working the case out. But I assumed when I read the indictment, like, hey, this is a guy with no criminal history, because you were charged with possession of a firearm during commission of a felony, but not the offense that I typically see along with that, which is, and this guy shouldn't even have had a gun because he's a convicted felon. Then I hear from Ms. Bostic, you got 5 felonies. So I'm not saying you had a gun on February 15th when you got into it with Ms. Jones, but you better not have one going forward. If you and I are together in the next few years and the arrest is, it was just a gun, I didn't shoot anyone, it's going to be prison time for you. And you don't need that. Your 1-year-old doesn't need that. So carry a baseball bat, carry a magic wand, but no firearms. Understood?
Yes, sir.
Good. Or whatever you use with cement, carry a cement weapon, but no firearms. Do you have questions about any of the things we discussed about you or your case?
No, sir.
Ms. Jones, it sounds like you had only known for just a few weeks. Is that accurate?
Yes, sir.
Okay. Have you had any contact with her since this incident?
No, sir.
Okay. So it sounds like it'll be easy to stay away from her. Well, Mr. Daniels, I find there's a factual basis for your plea. I hear Mr. Majeski loud and clear that there are probably 2 versions of events as to what happened, and it ultimately would result in a he said, she said, because there weren't witnesses to whether you pulled a gun or not. But it sounds like the young lady did have a big old lump on her head, and those don't just grow there. So I understand why you're wanting to work this out. I find that your plea is knowing and voluntary. Knowing means you understand what's going on. It's not your first rodeo. And voluntary means that after you've had a chance to think about it and consult with your lawyer, you've decided this is the right way forward for you. Is that a fair statement?
Yes, sir.
Mr. Majeski, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith, can we sign for you?
Yes, Judge.
Mr. Daniels, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
Okay. Here's what I'm going to do. Oh, let me ask one more question of Ms. Simpson. Did Mr. Daniels get revoked in both cases? Okay. Because I'm going to try to close those out, but I really can't because this plea doesn't, they'll just all run concurrently with each other. All right. You're only going to have one probation officer. Where do you live, Mr. Daniels? What county?
Living alone.
In Fulton County or DeKalb County?
Fulton County.
Okay. All right. Well, you're going to be on probation as a result of this case. So you're actually going to be on probation for 3 cases. That doesn't change a whole lot for you other than that you could be revoked in 3 different cases if something bad happens, which I hope it does not. But for this case, your most recent one, I'm sentencing you on count 1 to 1 year to serve 5 months with the balance probated. Count 2 is 5 years It must run consecutive to count 1, and I will probate that. And count 3 is 5 months to serve, and that'll run concurrently with count 1. So it's actually going to be 6 years to serve 5 months. I'm knocking 1 year of probation off. 5 years from now, you and I aren't going to be doing it. If you're going to mess up, it's going to be soon. And we don't need to have probation hanging out there forever. You got forever on probation in these other cases. And it would be fine by me if at age 50, you're not on probation anymore. So let's have that be your goal. When you cut that cake with 50 candles on it, my hope is there's not a probation officer there with you asking for a slice. Okay?
Thank you, sir.
Well, that's on you. That's up to you to make that happen. Special conditions of probation. This is where the work comes in for you. Number 1, the obvious one, no contact with Ms. Jones. Don't look her up online and say you're sorry or I'm going to get you or anything like that. Also stay away from that address on Fairburn Place. You live anywhere near there?
No, sir.
Okay. You're going to need to get your GED within the first year of your probation. Sounds like you're already underway. You got 1 year to finish. What's the hardest subject for you?
Yes, sir.
What are you finding to be the most difficult subject as you get your GED?
History, not really like science.
Okay, well, you got a year to work out the science part. You have to do 60 hours of community service. Those you need to complete within the first 6 months of your probation. And I'm front loading all this so that you're more likely to have your probation officer say, well, you've done all the things you needed to do. Let's close this out early. You'll need to take an anger management course within the first 6 months of your probation. And we will reconvene if the state files a motion to talk about restitution. There's no dollar amount in front of me right now. Mr. Majeski hasn't had a chance to evaluate any medical bills. But if Ms. Jones does provide medical bills, Ms. Smith will get those to Mr. Majeski, and if we need to have a hearing, we'll have it. It may be that he doesn't want to contest it on your behalf, but for now, I won't put anything in there on restitution. So that is the situation. Ms. Smith, anything else from the state? You sure? You paused. Did I miss something?
No, well, did we talk about the Fourth Amendment waiver and community service or?
I got community service. I forgot about the Fourth Amendment waiver. And all that Fourth Amendment waiver is, Mr. Daniels, is that if probation is working with you and like, wait a minute, you've been acting kind of funny and want to search your car, they can search your car. They don't need a search warrant. But since you're not going to have a gun in your car, that's not going to be a problem. Mr. Majeski, anything else on behalf of Mr. Daniels?
No, Judge.
Mr. Daniels, you got any questions for me?
No, sir.
All right, Ms. Simpson, who you can see in the background, can you wave, Ms. Simpson? There she is. That's Ms. Simpson. She's with probation. She's going to give you some reporting instructions about probation, okay? Listen up.
Good morning, Mr. Daniels. Can you hear me?
Yes, ma'am.
So do you still currently reside on Wyndham Way?
Yes, ma'am.
Okay, so you need to contact your officer, Officer Flemister, on Monday, this coming Monday,
Yes, ma'am.
okay? You remember where the office is?
Yes, ma'am.
All right, contact your officer on Monday so she can advise you whether you need to actually come in or not.
Yes, ma'am.
Thank you.
All right, if there's nothing else, Mr. Daniels, good luck with everything. Single parenting can be challenging. Hope you're managing all that.
Yes, sir.
All right. Thanks, everyone.
Thank you, Judge. Judge, I believe that completes my business with you probably until April. Can I be excused?
Until April. You do know, I'm going to see you before then. You've got this ancient case that non-complex kicked to us 3 years in.
That's right, I got most of it.
Seingar, I don't know, it's a drug case and you're trying to suppress something. And I saw that's, I think in early March is right around the corner.
Apologize, that is set for March the 9th. I got a motion to suppress and a motion to return property. For some reason, they kept his car all this time.
We'll talk with the prosecutor. We'll see what happens. If it's not sorted out, we'll see you on the 9th, my mother's birthday, and we'll work through that.
Thank you, Judge. Can I
All
be
right.
excused?
Yes, sir.
Have a good weekend.
I do not see an interpreter yet, so should we just go through the calendar? Do Mr. Watkins next? We go with,
Please.
Coney is in the waiting room. Let's do that. Look at that.
I did get a chance to speak with her. She said that she's responding, she'll come up for that week.
Okay, great. Oconee is joining. Oconee has joined. Great. So we're going to actually go to position 3. Hey, Mr. Kilpatrick, can you hear me?
Yes, Your Honor.
Great. Thank you to the good folks at the Oconee County Jail for getting you online. We were supposed to actually have you come all the way down here. Didn't happen, but I think we can take care of business. Let me get your attorney on the screen. There she is. And did you put some button on there? No, the camera went off.
You started again. That's what I was saying yesterday.
But it was working. Okay. Well, given that Mr. Kilpatrick's on the screen, why don't you, was it a pain to read? If you can just stay right there. What? Okay, he's going to make the camera work. We'll figure this out. He can, Mr. Kilpatrick will be able to hear you. Let me get his paperwork. There it is. Shouldn't you be running somewhere to get that person? Good to know when there's unauthorized access, deputies like, hey, what are you doing today? Anyone got gum? Sheesh. Okay. All right. Let's get on the record, please, in Mr. Kilpatrick's case. Mr. Kilpatrick, you are joining us today from Oconee County in connection with a probation revocation situation. I signed a warrant in December of last year indicating you had violated your probation. You were arrested in September of last year for failing to appear for something. And probation tried to connect with you in August of last year at the address you had given, which was Continental Colony Parkway, an apartment there. Couldn't find you. You didn't report. So it's sort of an absconding. But I also got an email that says you picked up a conviction in Douglas County. And so we need to, I guess, talk about all those things, unless the Douglas County situation is news to you, Ms. Wood.
No, Judge, I know about it.
Okay. And Mr. Kilpatrick has 4 years and a little more than 9 months remaining. Have you had a chance to speak with Mr. Kilpatrick?
I have, Judge.
Great. Then I'm going to have you speak on his behalf right now before I hear from him and Ms. Smith and Ms. Simpson.
Perfect, Judge. I think, so it's a revocation, but I think it's also going to end up being a resentencing. Since this,
because it's a first offender.
Sure.
Okay.
Judge, I did speak with Mr. Kilpatrick earlier this week. I got an updated address that he will be residing at. It is an Atlanta address. I've shared it with probation. I've also gotten a good contact for him. I spoke with, he was represented by Mr. Melnick over in Douglas. I spoke with Mr. Melnick this morning. He gave me a little bit of information about that Douglas County case. Mr. Melnick's perspective of the case is that actually there was a lot of mitigation. And of course, Mr. Melnick felt there might have been a way to get a different outcome. However, Mr. Kilpatrick had been in custody since last September over there. This was a probation offer, as you know. It's very hard for our clients to sometimes turn down those offers to get out of jail same day as a plea. The victim over in Douglas is actually still the partner of Mr. Kilpatrick. Mr. Melnick gave me her information. I've shared that.
This is Totsie Carter?
Yes, sir.
Okay, and he can have no violent contact with her, so they can remain partners.
Yes.
Just needs to be a non-violent relationship.
Correct. And from Mr. Melnick's work on the case, it very much, Mr. Melnick's perspective is that it was an isolated incident. Definitely, he thinks that this is something that they're going to be able to move forward from. And as you can see, he is going to complete family violence intervention program as part of his probation over in Douglas. Judge, he's got a job. I believe he is going to be able to return to it. He works for Coca-Cola. He's a forklift operator. He has 2 sons, ages 12 and 16. He's eager to get back out to them. I'm not sure how I should word my request of the court since he's been in since last September over in Douglas and then brought to Fulton and is housed at Oconee for our jail. I do want him to, or I want the court to understand that. And then I think the resentencing, I would just ask that he get the same that he's got for Douglas County, which looks like just a solid 10 years probation.
Okay. I'm processing all that.
Sorry, that was a lot.
That's okay. No, it's all helpful, and I appreciate you having done the work in advance. So math-wise, Mr. Kilpatrick, when did you get arrested most recently? When did you go into custody?
September 14th or 15th, I believe, Your Honor, of 2025.
All right, so you've been in now 5 months.
Yes.
Going on 6, it should be 6 months in the middle of March, I think.
Yes, sir.
Okay, got it. And your Douglas case was resolved with no additional jail time. It's 10 years probation.
Yes, Your Honor.
Okay, and Ms. Carter, who's the victim in that case, is different from the victim in the case you had with me. That was Alexis Steverson. Does that name ring a bell?
Yes, Stevenson. That's totally different, Your Honor.
Okay. Is either one of these young ladies the mother of either of your kids?
No, sir. Neither one.
Okay. Do your sons stay with you?
Not at the time, sir. My youngest one was staying with me, but he's with his great grandmother due to the fact that I'm incarcerated right now.
Great grandmother. Okay. When you get out, would your youngest be moving back in with you?
Yes, he will, but I'm gonna give it enough time so I can get all the way back on my feet. I will be visiting him from for the time being while he's with his grandmother, but as long as I'm up and back running, like due to getting everything back together on my end, yes, Your Honor, he will be back with me in my custody.
Okay. And when you get out, are you returning to, I don't know if you and Ms. Carter were living together or just talking with each other? Was that, you guys share the same place?
Yes, we were, Your Honor, for 3 years. We are going on 3 years. Well, yes, we have shared the same place, Your Honor.
Is that where you'd be going back to?
Yes, sir.
And what county is that in?
It's Fulton County.
Okay. All right. How did you end up with a case in Douglas County if you guys were living in Fulton?
Actually, Your Honor, in 2023, we moved out to Douglas County for a year. My spouse sister actually had it was efficiency lodge. It was a suite, something like efficiency lodge, like a small apartment or something like that. But my girl, my spouse sister was running it as management, and we went down there to help her out for a minute. Well, my girl was actually her assistant, and we just stayed down there for a year, and we ended up having a misunderstanding, and it's how this case came back there.
Got it. So it was while you were living in Douglas at the place you just described. Okay.
Yes, sir.
All right. Do you have any questions about what we've been discussing?
No, sir. My attorney, Ms. Casey, like she said, she has spoke with me and she has been very clear, and no, Your Honor, I have no questions.
Okay. Ms. Smith, what are your thoughts about how we handle this?
Yes, Your Honor, the state will be asking for the defendant's first offender status to be revoked and for him to be resentenced in the original case because of this new conviction out of Douglas County and also the charges that he was convicted of. We believe that they are violent charges that would increase the risk or the concern for the state that the defendant, by being on probation, will continue to commit further crimes. in this case particularly, he took the plea for the underlying case in January of 2023, and this new offense happened, although he was just convicted of it this year, it happened in 2024, so just a year after he pled guilty to this case. So because of how close those cases happened and the violent nature of the crimes he pled guilty to down in Douglas County, the state will be asking for his first offender status to be revoked and be resentenced at the discretion of the court.
Okay. Thank you. Ms. Simpson, anything you want to add?
No, Judge, probation is in agreement with the state.
Okay, and it sounds like Mr. Kilpatrick would be supervised out of Fulton if that's the address he's got. Okay. All right. Mr. Kilpatrick, I'm looking at the sentence that I gave you in the case where Ms. Steverson was the victim. One of the conditions was no contact with her at all. That's different from how it's structured with Ms. Carter. So you're going to need to continue to stay away from Ms. Stevenson. That's something you can do?
Yes, sir. Absolutely.
Okay. You were also supposed to get your GED. Did that end up happening?
No, Your Honor, but I plan to absolutely go ahead and get that right away, Your Honor.
Okay. How far did you go in high school?
11th grade, Your Honor.
Okay, almost there. You were supposed to complete a psychosexual evaluation as part of your sentence in the first offender case. Was that something that ever happened?
It was ongoing, Your Honor, but when this incident happened, it stopped.
Meaning you were getting some counseling?
Yes, I was.
Oh, okay, good. All right. Do you have any questions about anything else?
No, Your Honor.
Well, Mr. Kilpatrick, I find that your Douglas County case, along with you having absconded, meaning probation couldn't find you, together are reasons to revoke your first offender status and resentence you. I will resentence you to a parallel sentence to the Douglas County case. So it's not going to extend by very much your time in custody. Then the probation will just run at the same time in the two cases, the Douglas County case and the Fulton County case. I'm going to resentence you on count 1 to 10 years to serve 6 months with the balance on probation. You'll get credit for the time you've been in. Count 2 will be 10 years to serve 6 months with a balance on probation. And count 3, which is a misdemeanor, will be 6 months to serve. Those will run concurrently with each other. So it's a total sentence of 10 years to serve 6 months. And that sentence overall will run concurrently with your Douglas County sentence. I am changing the special conditions of your probation. We don't do Probation Options Management Act anymore. So that's out. You will need to continue your psychosexual counseling. So that's condition 1. You are to have no contact with Alexis Steverson. You'll need to stay away from 537 Boulevard. That's the address that you and Ms. Steverson had this situation. You're going to need to obtain your GED within the first year of your probation. And I'm adding the condition that you complete a family violence intervention program. That already exists in your Douglas County sentence. You only need to complete one. It's actually a series of classes and not just one class, but that's gonna be a requirement in both cases. And I'm doing that because if for some reason you decide you're not gonna do the family violence intervention program, I want the ability to revoke in the Fulton case. I can't do anything with the Douglas case if you violate those terms, but I can with the Fulton case. And I think to Ms. Smith's concern about, gosh, it wasn't all that far after you were sentenced in the Fulton case that you picked up this DeKalb case that had the Douglas case that has some of the same elements. You getting that family violence intervention program is a good thing. So that's how I intend to handle the revocation. Ms. Smith, was there anything more you wanted to have included in that?
No.
Okay, Ms. Wood?
No, Judge, thank you.
Mr. Kilpatrick, any questions about what I just did?
No, Your Honor, the 6 months, is it credited, for the time that I already sat down?
Yes, sir. I don't think you're quite done yet, but it is a sentence that will not get you sent down the road. And so it may well be that the sheriff's team says, look, this is close enough. They'll do that math. They control it. But the most you would do would be to serve out until, I may be a little off, but like March 13th or March 14th. That gets you to the full 6 months.
Okay.
Okay. Ms. Simpson, is there anything else that you need to share with Mr. Kilpatrick? Okay. So Mr. Kilpatrick, you'll need to report within 48 hours of your release to the probation office in Fulton County. Do you know where that is?
Yes, sir, I do.
Okay. Don't miss that, because we already had this one warrant that started out as we couldn't find him, and then it got more complicated because of the Douglas case. But you need to make yourself easy to find, okay?
Yes, sir. And Your Honor, when I do get out, so I report strictly to Atlanta probation, not Douglas County, correct?
Where is it that you'll be living?
I'm in Atlanta.
Then yes, sir. You report to Fulton County Probation. It's on Memorial Drive. They're going to have both your cases. They're going to have your Douglas case and your Fulton case. You're going to have one probation officer who is working with you on both your cases.
Okay.
Got it?
Yes, sir. Thanks, Your Honor.
Great question. Anything else?
No, that'll be all, Your Honor.
Okay. Well, thank you to the folks at Oconee County for getting Mr. Kilpatrick on the call. You are good to go, sir.
Thank you, Judge.
You're welcome. Our interpreter, our translator is here, so we are going to pivot to Mr. Gamba Mateas. Ms. Rios, do you need to meet with him with the interpreter before he comes out?
No, we went over everything. It's a plea.
It is a plea.
Thank you.
We're doing it without it. It doesn't matter. I can move.
It's still waiting. His name's
Oh, I'm sorry. I forgot we don't have the prosecutor. You have a prosecutor.
Okay, so we wait. Yes. Oh, yes, ma'am. Thank you.
Hey, thanks. Instead of saving us from the intruder, you did this. This is also value added. So, she's on her way, like we should bring him out, or should we?
She said she's still in squall, but I told her to interpret it.
Okay. Okay. We should wait. So sorry, Mr. Gamba Mateas. It'll happen. What else? Is Mr. Price's bond hearing pretty straightforward? I don't want to lock into the plea because if Ms. Nix gets in here, okay, I want to be able to work with our translator. So Mr. Price, please. And there is a Price on the call?
That's his mom, Your Honor.
Okay. All right, let's get on the record with, give me 1 second, Mr. Price. Screen's working, but it dropped it from the call, so I'm gonna add it. Don't touch anything. It's joining. For some reason, the wait room feature is on now. Everyone gets, but now it says the camera's off. Oh, now it's working.
Okay.
Excellent. Okay, sorry about that, Mr. Price. I'm gonna mute it. Mute that. There we go. We had to get some of the equipment working. We're gonna get on the record in your case. This is 25 SC 007-619, State versus Price. Mr. Price is here with his lawyer, Ms. Rios. We've got Ms. Smith from the state. And Mr. Price, all we're doing today is talking about bond. Ms. Rios filed a motion to talk about bond. She's going to let me know if you've got one, if it should be lowered, if you don't have one, why you should have one. I'm just going to flag up front. I'm going to want to know about all your other cases because this case is indicted with me, your lawyer, prosecutor, something we can move forward. But I've got down on my notes that you may have 3 other sets of felony charges. And so I'm going to hear about it. You saw you sort of furrow your brow. But that's what I'm going to need to understand is why bond makes sense if we've got a whole bunch of different cases. So Ms. Rios is going to get started. I'll hear from the prosecutor. I may hear also a little bit from some of the folks in the jury box. Ms. Rios.
Yes, Your Honor. Mr. Price is 17 years old. He's currently was going to school before he got incarcerated at Metropolitan for his GED. He lives with his mother who's on the call, and he has 3 siblings that also live with him.
Mr. Price, are you the oldest, the youngest, or in between?
The middle child.
Middle child.
And I'm asking for a bond of no more than $3,000 on this case. He has bonds on his other cases. He has had issues in the jail. I believe he was stabbed in the jail. And so he's very eager to get out for his safety. And hopefully his mother will be able to make a bond on all the cases. I know he does not prior to these open cases. I don't believe he has an extensive juvenile history either. So we're just asking for a bond they can possibly make.
Okay. Ms. Bostic, how many cycles do you have for, excuse me, Mr. Price? Oh, okay. When did you turn 17?
April 8th.
So you turn 18 in a couple months.
Mm-hmm.
Got it. Okay. Where did you go to high school before Metro?
Tri-Cities High School.
All right.
Point.
Ms. Smith.
Yes, Your Honor. In this case, the state will be asking for no bond for 3 different reasons. First, the state believes that the defendant may be a danger to the community based on the crimes alleged in this case and also the charges in the other 3 open cases that the defendant has. Starting with that burglary charge is, and I don't want to get into the facts, but going into someone's home when you're not invited.
I want to make sure I'm following. You're talking about when you say that burglary charge in this case, or are you sharing with me the unindicted cases?
This case, Your
This
Honor.
case. Okay, got it. It is a burglary.
Yes, in this case, we have before us, the state believes that the defendant, if released, may be a danger to the community because the defendant is going into people's homes without their permission and taking their property. So the state does believe that because of the nature of these crimes that we have in this case and the a violation of privacy for the victims here, we do believe that the defendant may be a danger to the community. Secondly, Your Honor, we believe that the defendant may be a risk of reoffending if he is let out on bond because of the 3 open cases that he has. We do understand that he does not have any cycles as an adult. However, because these are 3 open cases with very similar charges happening very closely together, the state believes that if the defendant is let out on bond, that there is a high risk of him reoffending. The 3 open cases happened, one October 10th, 2025, the second one October 22nd, 2025, and the third one November 2025. So these back-to-back open cases with very similar facts and circumstances in a total of 4 different other victims, the state does believe that there is a very high risk of the defendant reoffending. And lastly, Your Honor, the state believes and is asking for no bond in this case because we do believe that there may be witness intimidation. The state was able to speak with the victims in this case, who informed us that the defendant came to their home twice. The second time he came is the charge that is for the case that we have before us today. But the first time he just, went through their cars, and the second time he actually went into the home. And they believe that if he's let out on bond, that he may come back. They're afraid and they are opposed to bond. So because the state believes that the defendant is a danger to the community, that he has a high risk of reoffending, and that there may be witness intimidation, the state will ask for no bond in this case.
Okay. I've been able to look at just 2 of the 3 unindicted cases. One of them is entering auto. Another was having a mask and tools for a crime. It sounds like it hadn't morphed all the way into an entering auto. What's the third one?
Entering auto.
Another entering auto. Okay. And it also sounds like the indicted case is from that same time period. It's another October was a busy month, allegedly, for Mr. Price.
October 7th, 2025.
Okay. Got it. Okay. And I guess you have no visibility into why the indicted case gets indicted, but the other 3 don't. As opposed to focusing on an individual saying, here's, not that they should be indicted together as in one document, but here's a defendant with 4 PI cases. Wouldn't we want to indict them all together so his 4 cases are going at once?
Yes, Your Honor, that is our intention. I did, after this, we were intending to go ahead and get those accused so they can go and travel all together when they're on these dockets.
Okay.
Not sure why they weren't indicted all together.
Okay. Got it. Ms. Rios, anything you want to add?
Only that I understand that he has several open cases. They don't seem violent in nature. He wasn't alleged to have a gun on him or to be attacking anyone. It seems like there might have been something going on with him in October. Not sure how this all occurred. He does have his mom on the call, who is, I'm not sure what was happening at the time, but I know she has indicated to me that she does want to keep him on the right path.
I hope so. We all do, actually. Mr. Price, the address I have for you is on Dunlap Avenue. Is that a familiar address? Is that your mom's place?
Yes, ma'am. Yes, sir.
Okay, that's where you were staying back in October, November? Yes?
Yes, sir.
Okay. And you got arrested, I guess, in early November.
November 6th.
Okay, and you've been in since then?
Yeah.
Okay. It sounds like something bad happened at the jail.
Yeah.
Did you get jumped by a lot of people, or it was a one-on-one?
7 people. Twice. Now I got stabbed on December 24th. Yeah.
Okay. Any reason you can think of why people don't, you seem like a nice guy, you're not a big guy making trouble?
It was just a bunch of gang stuff, and I'm not a part of the gang, so
Okay.
it was just free fall, I guess.
Got it. What floor are you on?
I'm in UNC, so I'm on G-Pod, 7G pod.
Okay. Since December, so we're now almost at the end of February, so it's been a couple months. It been a little better or still? I'm not asking, is it nicer to be there, but you haven't been jumped since then, or?
I ain't been jumped, but I got tased the other day because somebody tried to run in my room and do the same thing again.
And that person tased you, or the DO in trying to get everyone under control?
Get everything in control.
Tased everyone?
He just tased me. He
Oh.
tased me.
Okay. That doesn't sound fun either.
Nah, it didn't. I was screaming. I ain't gonna lie.
Okay. Sorry that happened. All right. Well, Mr. Price, you're in a tough spot. You got 4 cases. They are all close in time. Something was going on or not going well in your life. Allegedly, you're not admitting to anything. You're not guilty of anything. You're standing in front of me with the presumption of innocence in your favor. But there are all these different incidents, and I need to be comfortable that wherever you end up is a place and with some guardrails that we're able to install that ensure that you stay safe and that you stay out of trouble. And I don't think just putting you right back where you were does that. I also think that it would be helpful, it sounds like the DA's office is working on it, to get all your cases together, so that you and Ms. Rios can look at all of them and say, how we're gonna work through this. So I'm not gonna set a bond right now. I am gonna reach out to the jail to see if you ought to be moved somewhere different, whether that's somewhere in the same facility or to a different facility. I don't want to ask that you get put in lockdown, not because you've been bad, but so you can be safe, because I often hear back from the lawyer saying my client would rather be out in general than in lockdown. It's a little less safe, but it is not as oppressive as being stuck in one place 23 hours a day.
Oh, that's what I'm already doing.
Pardon me?
They already got me doing 23 hours a day.
Really?
Yeah.
If Ms. Smith were to ask the jail for your disciplinary records, would she find that you're getting locked down because you did something, or this is more to keep you safe?
Ever since I got jumped that one time, they moved me over there.
Okay, so that place you described, Geo, that's your 23 hours down?
They only get 1 hour up.
Okay. All right.
Your Honor, I'm not sure if his mom wanted to say anything. Can we see if she did?
Okay, I don't want to preclude her from saying anything, so let's ask. Ms. Price, was there anything you wanted to add? You don't have to say anything at all. Hopefully you've been able to hear us and see your son on the screen there. Was there anything you wanted to add? Okay. I am going to ask Ms. Smith to have this on her priority list. I know you don't run the charging unit, but if they could try to get those other 3 cases, they'll all come here. But so you have one judge, one lawyer for all your cases. And then Ms. Rios, once you see that they're here, let's figure out what we're going to do with them. And if there is some material change in the circumstances, you get discovery and you think, you know what, we actually need to talk a little bit more about what these cases are about. I think I understand what's going on, and I see the pattern here. I don't think getting Mr. Price out right now is the safest thing for him or for the community. So for now, I'm going to keep you in no bond status. But if this drags out, not because of you, then we'll get back in here and talk about that again. Okay? All right. Thank you, Ms. Rios.
She did text me. She said it wouldn't allow her to speak. She wanted to, but it was muted.
Oh, well, let me see if that changes anything. I can't unmute. I just clicked ask to unmute. Maybe that'll give her a button to click.
She said it was muted.
Oh, she's on.
Yes, I just wanted to say that if we can expedite the situation of getting all his cases put together. I was in the trying to unmute it, so I'm not sure if that was already addressed.
It was addressed. I share your concern and interest, Ms. Price. And I had just asked, the prosecutor in here doesn't get involved with the charging things, but she can certainly reach out and let them know that we've got 3 matters that they need to hurry up and decide, are you going to charge it or not charge it? So we can get them all together. And that's exactly what I said. I explained to your son that I'm anxious to get them all here and quickly, so that your son and his lawyer can think about how do we wrap all this up into one thing, whatever that is, a plea, diversion, a trial. That's going to be up to your son and Ms. Rios as they look at the evidence and say, well, you know, these are not real good cases for the defense. We need to try to work them out. Or it's real clear they got the wrong guy. The person on video was 6'4" who was doing this, and Mr. Price is not 6'4". They got the wrong guy. So my goal is to move it quickly as well.
Okay, thank you so much.
You're very welcome. All right, that's it for now, Mr. Price. We'll see you soon. Semi-perfect timing, Ms. Nix. We just finished another matter.
We're gonna do that, interpreter plea now?
Yes, ma'am.
Okay, just to make sure. Okay.
We're ready for Gamba Mateas again, this time for real. Ms. Nix, was that your first Judge Emerson trial?
As first year,
Yeah? How'd it go? I mean, I know the result, but I mean, you survived.
I barely.
Barely.
Y señor, okay, vamos.
Morning.
Let me know when you're ready. I know you're transitioning from another courtroom.
No.
All right. Let's start by swearing in our translator. Do you swear or affirm that you will translate to the best of your ability from English to Spanish and Spanish to English?
I swear, Your Honor.
Thank you. And can I have your name for the record?
Andrea Fitzgerald, Georgia Certified Interpreter.
Thank you so much. This is indictment 25 SC 005 757. State versus Gamba Mateas. Good morning, Mr. Gamba Mateas.
Good morning, sir.
Mr. Gamba Mateas, because we're using the translator, I need you to wait until she has translated into Spanish everything that is said in English before you answer, even though you may understand what was said. You are free to answer in English or Spanish, but it's what the translator says on your behalf that's the official record. Does that make sense?
Yes, sir.
You're supposed to say yes, sir, when he says yes, sir.
Ah, sorry, I didn't know how to repeat the.
Yes, because what you say is the,
Yes. Yes.
okay. Even though we all understand what he said, there may be times when he answers in Spanish and then you are translating, and it's for a record, it's everything you say.
El acta se basa en lo que yo digo, así que si vos contestás en inglés, yo tengo que repetir en inglés, por eso me confundí.
Okay.
Vos contestá como vos quieras, yo interpreto.
Mr. Gamba Mateas, if at any point you have a question, will you let me know?
Sí, señor.
Yes, sir.
Great. When you're ready, Ms. Nix.
Thank you, Judge. Mr. Gamba Mateas, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down. Please state your true, correct, and legal name.
Sebastian Felipe Gamba Mateus.
Sebastian Felipe Gamba Mateus.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
No.
How old are you?
31.
31.
How far have you gone in school?
Soy bachiller. Terminé la escuela.
The interpreter would like to clarify. Bachiller is in high school?
High school.
Okay. I finished high school.
Do you understand that you have been charged with the following offense? Peeping Tom.
Sí.
Yes.
What is the Spanish phrase for peeping Tom?
¿Cuál es la frase en español para peeping Tom?
Espiar.
Hay varias. There's several. It can be fisgón, can be mirón, can be espiar.
And what does that last one mean? Spying?
Yeah, that's why I didn't use that, because spying is more like, movies, James Bond, espiar.
Okay.
So fisgón is more like the street war. No sé
Okay.
si tú conoces por fisgón.
Sí, como mirar.
Yeah, to look, fiscal. Yeah, just several.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
En un juicio, ¿me entiendes?
Sí.
Yes.
Have you had the opportunity to review your rights with your attorney?
Leer el documento con todos tus derechos junto a tu abogada.
Sí.
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to this charge?
Yes.
Do you need more time to discuss the case with Ms. Rios, your attorney?
No.
Are you satisfied with her services?
Mucho.
Very.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Gamba Mateas, do you remember having been arrested on this charge?
Sí.
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court?
Entonces, la fiscal le envió cuál sería la sentencia apropiada. ¿Tú entiendes eso?
Sí.
Yes.
The state's recommendation is 5 years of probation
De libertad condicional.
with the conditions of no contact with the victim and stay away from the incident location.
El lugar donde ocurrieron estos hechos. Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Esta recomendación, ¿me entiendes?
Sí.
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Que la letra del caso, ¿entiendes? Que él lo podría hacer.
Sí.
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today,
No declaraste.
that you have the right to withdraw your plea of guilty?
¿Entiendes eso? Yes.
Are you currently on probation or parole anywhere?
¿En otro condado?
No.
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Del Estado federal.
Sí.
Yes.
Do you understand that while you are on probation, you must follow all the special conditions of your probation?
Cumplir con todos los requisitos que se te pida. Okay.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence.
Yes.
Yes. Do you understand that you are not allowed to possess or use a firearm while on probation? Yes. Are you a United States citizen?
No.
No. Do you understand that a guilty plea conviction will affect your immigration status?
Puede tener un impacto negativo en tu situación inmigratoria, ¿lo entiendes?
Yes. Do you understand that a conviction through a guilty plea will result in deportation
Podría resultar en tu deportación.
in just the same way that a conviction at a trial would?
Ese es que si te hubiesen encontrado culpable en un juicio, ¿lo entiendes eso?
Sí.
Yes. Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
No puedes tener un arma, ni transportarla, ni usarla, ¿lo entiendes?
Sí.
Yes. Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Contra, ¿lo entiendes?
Yes. Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Para cometer un delito en un futuro, ¿lo entiendes?
Yes. Do you understand that if you were in the future to use a firearm during the commission of a crime,
Durante la comisión del delito,
you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
más los años que te faltarán de libertad condicional, ¿lo entiendes?
Sí.
Yes. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Primera ofensa en tu declaración a cargos.
Sí.
Sí.
Yes. Have you ever pled guilty to a felony in the state of Georgia?
Felonía usando la primera ofensa.
No.
No.
Have you ever pled guilty to a felony in any other jurisdiction?
Culpable de alguna felonía en cualquier condado o jurisdicción.
No.
No.
Have you ever been sentenced for a crime, felony, or misdemeanor under the First Offender Act?
Tenía un cargo menor, pero usando la primera ofensa. No.
Has your lawyer explained the First Offender Act to you?
Lo que significa declararse como primera ofensa.
Sí.
Yes. Do you understand that if you violate the terms of your first offender sentence
Usando primera ofensa.
or commit a new offense while on first offender probation, your first offender status could be revoked?
¿Entiendes?
Okay.
Yes. Okay, yes.
This means that you could be adjudicated guilty and resentenced up to the maximum sentence for each charge in this indictment.
¿Entiendes?
Yes.
Yes. Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Si fueras a un juicio, ¿lo entiendes?
Yes. Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury,
Juicio frente a la
to remain silent,
quedarte en silencio,
to confront witnesses against you,
hacer los testigos que vinieran,
to the assistance of counsel,
tener un abogado presente durante el juicio,
to the presumption of innocence,
su inocencia,
and the right to appeal if convicted of these charges at trial.
esa culpabilidad si es que te encontrarán culpable en el juicio. ¿Entiendes? Que renuncies a todos esos derechos. Yes, I understand.
Is it your decision to waive these rights
Decisión.
and enter a guilty plea today?
¿Me doy?
Sí, señora.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Algo para que te declares culpable.
No, señora.
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
De hecho, tú eres culpable. Yes.
How do you plead to the charge
Declarar.
of peeping Tom in indictment number
En la acusación.
25 SC 005757?
57.
Culpable.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Voluntaria, inteligente y sabiendo las consecuencias. Yes.
Do you understand that if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court
en tu acusación
to request a discretionary appeal
al de alta instancia que lo arreglen
as outlined in OCGA
en la OCG
5-6-35 within 30 days of today?
si quiere corregir algún error que haya. ¿Entiendes? Okay.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition
Fue voluntario. Ya, puedes hacer lo que se llama un habeas corpus.
And since this is a felony, you have only 4 years from today to do so.
¿Entiendes? Okay, yes.
Judge, had this case gone to trial, the state would expect the evidence to show
Okay.
that on or about June 26, 2025, the defendant Sebastian Gamba Mateas did go on the premises of the McDonald's bathroom
Del baño de McDonald's.
located at 6049 Roswell Road, which is in Fulton County,
Está en Fulton County.
which, for the purpose of peeping through the bathroom stall to spy upon and invade the privacy of Bansikita Batu, Bansikita, Batu, Batu. And that occurred in Fulton County.
Esto ocurre con la orden.
Do you oppose first offender, neutral,
Neutral.
part of what was negotiated?
We are neutral on first offender.
Okay. Ms. Bostic, criminal history information, please.
Judge, he has a hold, immigration hold. At the time of his arrest, he had a hold for 2 misdemeanor cases. He took a plea on both cases since being on custody, a battery family violence and a simple battery family violence. One, he got time served and has to serve 186 days, and the other one is 12 months probation. Victim was Andrea Sanchez, no prior felony convictions. There's a hold for an FTA on a traffic offense out of Shannon. Last arrest was the simple battery 4/23/24.
And how many total cycles?
7.
Siete acusaciones ha tenido.
Thank you. Ms. Rios?
Yes, Your Honor. Mr. Gamba Mateo is 31 years old. He's originally from Colombia. He's been living in City Springs for the last 4 years. He does not have any children. He has been doing roofing work for the last 3 years.
Sorry, what do you say?
He's been doing roofing work. He was working at McDonald's also. And he did let me know that his father is very sick with cancer, and he does want to be out to be able to communicate with his father. In regards to this case, it seems like from my understanding, for him, it was a misunderstanding. His boss was saying there was someone doing things in the bathroom, maybe drugs or something, and indicates to him that they needed to catch that person doing that. I think based on the language barrier, I think he misunderstood what he was supposed to be doing. He understands that he may have understood and this is the situation that occurred, so that's why he wants to take responsibility. But he did not intend for this to occur. So we did.
Keep going.
We just asked for you to accept the plea as negotiated.
So Mr. Gamba Mateas was actually an employee at this McDonald's when this happened.
Yes, Your Honor.
And he's provided you with an explanation as to why he went into the women's room.
Yes, Your Honor.
He didn't walk into the McDonald's as a customer and make a beeline for the women's room.
Correct, Your Honor.
Okay. His father is ill. Is his father in the United States or in Colombia?
I believe he's in Colombia.
Okay. Anything else?
No, Your Honor.
Mr. Gamba Mateas, do you have any questions or anything you want to add?
No, sir.
No, sir.
Do you understand that this plea could result in your removal from the United States?
Sí, señor.
Yes, sir.
And any representation or promise that Ms. Rios may have made that you would not be removed from the United States is not binding, does not control what happens.
Sí, señor.
Yes, sir.
That's a decision for Immigration and Customs Enforcement.
Sí, señor.
Yes, sir.
They will not be asking me,
No me van a pedir a mí.
they will not be asking your lawyer, Ms. Rios, what should happen.
¿Qué es lo que va a pasar? ¿Entiendes?
Sí, señor.
Yes, sir.
Okay. And you still want to go forward with your plea, even though this may result in your removal from the United States?
¿Quieres declararte a pesar de que puedes ser deportado?
Sí, señor.
Yes, sir.
Okay. You would like to be sentenced as a first offender?
¿Quieres una primera ofensa?
Sí, señor.
Yes, sir.
The benefit of first offender is that this is not a conviction,
Tú vas a aparecer en tus antecedentes.
which will help with removal proceedings.
Is where I desire the most, sir.
Okay. There's a risk with first offender, however. If while you are under first offender sentence, you get arrested for something else, not only do you have the new charges,
Nuevo.
but you might have to come back here and I could take away your first offender
Sacar esta primera ofensa.
and resentence you
Sentencia
all the way to the maximum.
a lo máximo que permite la ley.
I don't know that I would do that, but I need you to know
Diciendo que es.
that that's a possibility.
Sí, señor.
Yes, sir.
Do you feel like you understand the benefit and the risk of first offender?
Primera ofensa.
Sí, señor.
Yes, sir.
And do you want to be sentenced as a first offender?
Yes, sir.
Okay. Mr. Gamba Mateas, I find that there is a factual basis for your plea. It may have been a misunderstanding for you, but it was very upsetting for Ms. Batu. I also find that your plea is knowing, meaning you understood what we talked about, and voluntary, meaning no one is forcing you to enter this plea. Do you agree with that?
Sí, señor.
Yes, sir.
Then I will accept your plea. Ms. Rios, can someone in my office sign the indictment for you?
Yes, Your Honor.
Ms. Nix?
Yes, sir.
Mr. Gamba Mateus, can someone in my office electronically sign your name to the indictment, indicating your first offender plea?
Electrónica. ¿Me das permiso?
Sí, señor.
Yes, sir.
I will sentence you as a first offender to the only count in the indictment, to a sentence of 5 years, to serve 7 months with the balance on probation.
Es en libertad condicional.
You will get credit for all the time you've already served. Special condition of probation number 1, no contact with Ms. Batu. Number 2 is you'll need to stay away from that McDonald's. That means you can't work there anymore, unfortunately.
Okay.
So if you are allowed to stay in the United States, you'll need to find a different job.
Tienes que buscar otro trabajo.
Sí, señor.
Yes, sir.
You will be released in the next few days to the immigration hold.
Inmigración.
Sí, señor.
Yes, sir.
Okay. Ms. Rios, anything else?
No, Your Honor, thank you.
Ms. Nix?
No, sir.
Ms. Simpson, anything you need to share with Mr. Gamba Mateas?
I would say report within 48 hours.
Sí, te dejan salir sin migración.
However, due to the uncertainty, if he would be released.
Wouldn't it be, he should report to probation within 48 hours of being released from all his holds? Okay.
So I will give him the interpreter in regards to address.
Where that is, great.
Ella te va a dejar saber dónde.
Ok,
Ok.
tengo una pregunta.
I have one question.
¿Cuánto tiempo se demorará la migración por ir por mí? O el tiempo para mi libertad.
How long Fulton will hold me here for ICE or immigration to come and get me?
Good question.
Muy buena pregunta.
The sheriff will notify ICE. ICE has only a certain amount of time, I don't know how many days, but not many, to come get you. If they do not, we release the hold and you start your probation.
Y empezarías a libertad condicional.
Al otro día me tengo que presentar si me dejan libre.
So if I get out of Fulton get out of Fulton, I have 24 hours to go to probation.
48 hours,
2 días, 48.
those días. And Ms. Simpson's going to come talk to you about where you go.
Va a ir a hablar contigo para decirte dónde tienes que reportarte.
Yes, sir.
Any other questions?
¿Alguna otra pregunta?
No sé.
No, sir.
Good luck.
Buena suerte.
Muchas gracias. Dios
Thank you
bendiga.
so much. God bless you. Ay, tiene que ver con este. Sí, sí.
Thank you, Ms. Nix. You heading back to Judge Schwall? Or you done?
Anything else on the calendar? I apologize. I'm sure that I got this calendar. I just-
You did get it. I don't think Mr. Ware, Ms. Smith, you got everything with Mr. Ware? I think that's all that's left. Oh, and Mr. Watkins. Watkins and Ware, but they're both Wood and Smith. So you're good? Take care.
Guess who I got a parole request for information about?
Wow, already? Who?
Gooder? Oh,
You know, he has still not left the jail.
yes, I know.
Yes, so does our staff. And we have been nudging the sheriff's team. Why is this guy not out? As in down to Jackson.
Yes.
Remember Mr. Goodher? He pretended to be a cop and abused this woman. He'd been in jail. He's done a whole bunch of time across 2 different arrests. He dialed in once from like his car out of state and wouldn't tell us where he was. So I signed a bench warrant. And Ms. Wood had to deal with him. He pled recently and he's wanting to get out big time. And he blows up our phones and the PD's phone. So we reached out to Ms. Ivy saying, why is he not on the bus to Jackson? She claims he's on the short list now. But he doesn't have much time left. I can't remember if it was 2 years or 3 years. I think it's 2 years that he got. And he's done 500 and something days. So there's still time left, but it's gonna be less than 6 months. I don't know I assume they'll just keep him at Jackson. But we need to get him down the road. If you got time. GUETTER. GUE. Yeah.
I'll reach out.
Okay. We should all be reaching out. Thank you. All right. Thank you, Ms. Nix. Would you like to do Watkins or Ware?
Sure. we can walk in, so-
Okay. One plea and revocation.
Go ahead,
Oh, you have something still?
No, I will leave.
Oh, okay. And then this afternoon, we have a plea, but it's with a private attorney. That's it? Choice Phillips? Okay. I'm guessing Mr. Gordon just wasn't free in the morning, because I don't mean to drag you here twice, but
I think he was given an option and he chose.
he picked that. Okay. All right.
The what? But talk to Joanne before you do anything, because Joanne was working on that yesterday. Okay. Because it's a mess. It's like each co-defendant has like 10 co-defendants. Yeah. Okay, I want to see. Yeah, tell someone to let you know. If you go to the office, go by Joanne's office. And there's, yeah, tell them. I don't know if I copied you or leave it. Shambles.
But wasn't he the one who had the probation, the health conflict handle his probation revocation because he has so much going on?
That I don't know,
Okay.
but it's a messy case.
Oh, well, I take them, but she had 2 cases and I just ended up taking them. And she was like, oh, okay. I see. You are the only one. So I was like,
Oh my God,
I care
what was the
about those too,
allegation?
but I feel like.
What was Watkins? Oh wait, who? Christopher Gooder, but it's spelled G-U-E. I can pull it up.
Do you need his case number or just his name?
You can give me the case number.
I'll look it up. Gosh, he's been in trouble a lot. It's 22 SC 184420. And he should have been shipped weeks ago. Oh, he's gone.
Oh, he's going already.
We're not already. I checked yesterday.
Today is, it's Tuesdays and Thursdays. So
Oh, really?
Probably going to bus this morning.
Let me check, but the orange J is gone. Yeah, it says released, but no, transferred to DOC.
Yeah.
Nice work, dude. Damn. That's impressive.
Well, thank you for taking that case, yeah.
So have you heard of David Banner? Does that name ring a bell?
Yes.
I was with him last night. Yeah, we were on a panel together. Dude's impressive.
I don't think he brought no more.
He acts now. He's into acting. He said he wants to do sci-fi. Okay. He's got all the money he needs. He's just trying to branch out in other ways. But although he said he may do some music for Grand Theft Auto 6, whatever the next number coming out, he shared with, it was at Morehouse. This was for Morehouse students. I don't know why I was on the list, but in Grand Theft Auto, when you're driving the car, you're able to play a radio. They said the soundtrack that you can play on the radio is going to be released only through Grand Theft Auto. And so he's going to make some tracks that will be, he'll make a ton and Grand Theft Auto will make a ton.
I haven't played Grand Theft Auto since Vice City.
Yeah.
So that was like 2000.
Oh my God, this sounds
Yep.
crazy.
Anyway, that's who I was with last night while you were in 3E. He's a very impressive speaker. He's got a lot to say.
Well, not like us. No, I know.
All right, sir.
Thank you so much. Yes, ma'am.
Oh, you're about to leave.
I don't cost you.
No, I'm not leaving. We have 2 more.
Just standing up.
Yep,
Stretching your
I like
legs.
standing up.
Oh,
right here?
Yes.
Yep. Thanks so much.
Thank you, Anna. See you soon.
Bye-bye.
I'll drop you down there. Okay. She's on the, drop down the road.
We're ready for Mr. Watkins when you are.
Down up, you're still trying to get Xavier, whatever guy.
Yeah, I am, but I'll let you.
Okay, no, thanks.
Is Mr. Watkins okay?
Think so? Why do you not think so?
See what's
Really? The grabbing gets you. Hey, what's your grandmother's name? Okay. So here you go. Just revocation.
Oh.
Yeah.
All right, let's get on the record, please. This is 15 SC 132862, State versus Dearius Watkins. Good morning, Mr. Watkins.
Good morning.
Mr. Watkins is here with Ms. Wood. Ms. Smith is handling the case for the state. And Mr. Watkins, we are together because just, it's an odd date. It says January 1st. I don't know that I guess I was working on New Year's Day. I signed a warrant for your arrest because you had violated probation in that you had been staying, I think, at a place called the Faith Project, which is a supportive housing location. And I think
Apparently suspended.
right, they were suspended, and then no one could find you after that. You didn't let probation know where you went. I'm gonna give you a chance to talk. I'm just letting you know what the concern was, is that they knew where you were, then they didn't know where you were. And as long as you're on probation, and you've been on probation for a minute, responsibility is ultimately yours. So even if there's something funky that happens, like, hey, just hold on. If you got to move, you need to be letting probation know. And they're saying you didn't. I'm gonna hear from your lawyer. I'll hear from you. Maybe you were blowing their phone up saying, hey, they closed this place.
That's the
We're
urgent care medication.
gonna work through it. We are gonna work through it. Okay? So that's it. That's the allegation. It's not that you got arrested again or anything. It's that you were at a place, then you weren't there anymore. And we just need to make sure we process all that. You have just under 4 years left on your probation. Okay? Ms. Wood.
Thank you, Judge. So Mr. Watkins is admitting to this violation. I'm not exactly sure what all happened with that address situation. I do know he's planning to live here in Atlanta with his grandmother and his mother. I've provided that location and their phone number to Ms. Simpson. He knows where to go to get his medication and everything he needs to continue with his treatment at Mercy Care. So, Your Honor, I think we're all in agreement to just revoke 30 days. He's already done that. He's been in 50 days and then reinstate to probation.
All right. Ms. Smith, anything you want to add?
No, we are all in agreement with that.
Okay. Ms. Simpson, anything?
No, Judge, Ms. Wood has forwarded me his updated address. So we have it.
Where mom and grandma are?
Yes.
Okay. Mr. Watkins, tell me what you want to tell me. You were starting to talk and I just needed to hear from these other people first, but I'm happy to hear from you.
My name is Shango. I'm blessed to be out. I got locked up when I was a teenager. And at first, everything was moving kind of fast. I'm sorry if I didn't update my address in time. And as far as my knowledge, I didn't know.
Okay. Do you have a place to stay now?
Yes, sir.
And who's that with?
My mother and my grandmother.
Do you know that address? It's okay if you don't, because Ms. Wood does. I'm just wondering if you know it.
I just took my Mercy Care medication this morning, so
Okay.
I'm still kind of drowsy.
Okay.
It will come back to me.
Okay.
That's why I have them as a caregiver. I never leave them, not unless they find me a job or something.
Okay.
The thing I do is through them, just to make sure this doesn't happen. That's why I'm still kind of confused.
Sure. Tell me what you take medication for.
PTSD. I got locked up when I was 16. They charged me as an adult. I did 10 years. I got out when I was 26 years old.
This is the armed robbery
That's
case.
That's
Yeah, okay, attempt, whatever it was, but the reason why you're on probation.
Parole.
Okay, well, you're on parole now. Okay. But you've got a safe place to go. That's mom and grandma. When you get released, how are you gonna get there? Are they picking you up? You taking a bus?
9 out of 10, I will call them to come pick me up.
Okay. And you think they'll be able to come get you?
Yes, sir.
How are you gonna call them? You know their number?
I will ask the officer before I leave the station to get their number.
Okay.
I know my grandmother's number. She can contact with my mom.
Okay.
Come pick me up.
Great. All right. I just want to make sure that's lined up because I don't want you to get stuck alone again.
Sorry about that. Will never happen.
And tell me where you get your medication.
There's a Mercy Care building. I remember it saying Mercy Care on the building. That's the only thing that kind of stuck out to me. I'm sorry.
Okay.
It's my first year on the street, really, as an adult.
Yep.
So it's still kind of fast for me, but I'm
Sure.
catching on. I'm ready to get a job.
Good.
I'm ready to take care of my daughter, and I'm ready to start my life.
How old is your daughter?
10.
10. Okay.
Should be 11 this year.
How long did you say you were in custody? For 10 years?
Yes, sir.
Got it. So your daughter was born just before you went in? Gosh. All right. Have you seen her since you got out?
Yes, sir. She's beautiful.
Good. I bet she is. She's growing up, so you need to get out and make sure you stay plugged in with probation. Don't make it hard for them to find you.
Never again.
Good. All right. Well, I'm hearing you say that. Never again. Mr. Watkins, I'm going to revoke 30 days of your probation. I'll give you credit for the time you already served. That means you will be released, if not today, then tomorrow. And that means you got to be in touch with your mother or your grandmother saying, hey, you guys got to come get me. The part I'm nervous about is the gap. I'm going to ask the sheriff to release you with some medication. Sometimes they do, sometimes they don't. But then we got to get you to mercy care. So you're getting your medication. Okay? Make that your focus. Then, like you were saying, once you get kind of stable and not drowsy, then you can plug in, go see your daughter, do things like that.
Yes, sir.
All right? What kind of work you hoping to do?
Construction work.
Have you done that before?
Yes. I was taught that. As a child.
Okay.
It was kind of like a piggyback type of thing.
Yep.
But I learned quickly.
Good.
And custodian is easy work. So
Excellent. And it pays, and that's what matters. All right, Mr. Watkins, I hope if I bump into you again, it's because you're working somewhere and not because you're coming through that door. Stay plugged in with probation. Ms. Simpson, do I need to request a mental health probation officer, or is that already in the mix?
I was gonna ask if you would be comfortable taking every.
Yes, let's do that. So let's modify probation so that Mr. Watkins is able to work with an officer who's tuned into PTSD and medication and all that and can make sure that's happening. Great. That's what we're going to do. Thank you, Ms. Wood.
Thank you, Judge. Ms. Simpson, is it 48 hours or a date? Okay. I'm gonna give this to you, okay? Yes, please. What is it? Okay. Huh? Okay. Okay. Thank you. That's your probation officer's number, and that's my number, okay? All right, good luck to you, Mr. Watkins. All right, take care.
Mr. Ware, how come you're making him do all the work? Just noticed the bar up there like, wait, what? Okay, why not?
He's the boss.
He is. I wouldn't say no. So just get the day off. You got Gooder out of here. I'm gonna call Colonel Edwards. Gordon's done for the day.
She left.
Yeah, she doesn't hang around anymore. She wanted to like be part of the team, but now. Good morning, Mr. Ware. Come right up here next to Ms. Wood. I don't have a warrant or a petition for Mr. Ware. I'm sure one had been sent long ago. Did we have, a lot of people on today's calendar had been on other calendars, but I don't hold on to that stuff. So if someone could forward something, that would be great. But it sounds like the violation is the new charges. Is it more, if it's not more than that, I'm happy going forward.
No, it's, position
Yep.
6 is the violation.
Okay.
I think also it's a technical violation of failing to get his GED, but that was.
No GED? Okay. Okay. Mr. Ware, good morning. Good morning. Mr. Ware, you are here for two cases, 26 SC 000-708. That is your new set of charges. It charges you with possessing or distributing a drug and obstruction of officers. And Ms. Wood tells me you're ready to enter a plea on that one. And in connection with that plea, there's a revocation of an older case from back in 2023. You got put on probation for a robbery charge. And you've been on probation in that case for a while. You've got 5 years and a little bit more remaining of probation on that robbery case. But it's a violation of probation to get arrested for new charges. So I think what we're going to do today, it's ultimately up to you and Ms. Wood, but Ms. Wood says this is the plan. We're going to handle your plea in the new case and deal with the revocation in the old case all at once, so that when you leave the courtroom today, you're done with your Fulton County business. Is that your understanding?
Yes, sir.
Okay. For us to do that, we'll start with the plea. Ms. Smith is going to swear you in, put you under oath, and then ask you questions about your case and your rights. At any point during that conversation we're having that you've got a question, you need to let me or Ms. Wood know. Will you do that?
Yeah.
Okay. Make sure you speak up when you're answering. Our court reporter is virtual, so she can only hear you if you're speaking loudly enough into that microphone. Ms. Smith?
Thank you, Judge. Mr. Ware, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Marcus Ware.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
22. The farthest I've been in school is 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yeah.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am. Okay.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Ware, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 8 months with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with another crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
And I know we already talked about this, but are you currently on probation?
Yeah.
Do you understand that if you're currently on probation, your probation may be revoked based on you entering a guilty plea here today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense.
Yeah.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Ware, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
As to indictment number 26 SC 000708, how do you plead to count 1, possession of a scheduled 1 or 2 controlled substance with the intent to distribute, and count 2, willful obstruction of law enforcement officers?
Yes.
Is he guilty?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Can you say that again?
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Okay.
Do you understand that that discretionary appeal procedure must be completed within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Ware. Your Honor, if this case were to proceed to trial, the state would show that on April 1st, 2025, officers were canvassing or in the area of 2452 Marsco, I'll spell it, Morosco, Morosgo Drive.
Morosco.
Yes,
Right.
that's in Atlanta, Georgia, zip code 30324, also in Fulton County. When the officers arrived to this address, they saw a male that when they noticed the police officer started to walk away and evading them, they started giving him commands like stop. However, he continued to run away from the officers. The officers eventually caught up to the defendant in this case, and when they were able to catch him, they detained him for running away from the police officers and eventually arrested him for willful obstruction. But after that, they searched the defendant where they found 15 Ziploc bags occupied with marijuana. That marijuana or that substance was tested by GBI and came back confirmed as THC, 52.17 grams. Because of that, the defendant was placed under arrest and was charged for the charges we have in front of us today. Regarding the negotiated plea between the state and the defense, we've agreed to for a sentence of 5 years probation for count 1 and for count 2, 5 years to serve 8 months with the balance probated. And then for count 2, willful obstruction, 12 months probation, so run concurrent with count 1. As far as special conditions, the state is recommending a drug and alcohol abuse evaluation, a Fourth Amendment waiver for the defendant to complete his GED within 1 year, and for the defendant to have no drugs without a valid prescription. And that's all from the state, Your Honor.
Got it. Thank you. Ms. Bostic, criminal history information for Mr. Ware.
One out of Illinois arrest for resisting officer and felony inducing witness from 8/10/24 with no disposition. He's had 2 cycles since this arrest. One is out of the cab, 10/2/25 for giving false name and misdemeanor obstruction. And then he was arrested on this probation violation and a new misdemeanor obstruction and fair evasion. And he took a sentence since been in jail, plea 11/6/25. His only felony is the probation case.
Got it. Thank you. Ms. Wood.
Thank you, Judge. So Mr. Ware is 26 years old. He is a lifelong Atlanta
You
resident.
22 or 26?
Oh, I'm sorry, 22.
Okay,
Can't read my
it makes a difference to me, so I was curious.
Yes, it's
Okay,
22. I'm so
22.
sorry. My handwriting is terrible. Yes, 22 years old. He's a lifelong resident of Atlanta. Your Honor, I've been working with Mr. Ware for a very long time. I had his original case, as you know. We have actually gotten him into, there's a new program that the Maine Public Defender Office is.
Maine is in state of Maine?
Yes. Oh, I'm sorry, like GPDC headquarters.
Got it.
Central office, I think is what they're officially called.
Okay.
So their social services department is starting a program. It's called Ladders Program. It is a holistic support program designed for justice-involved youth and young adults aged 16 through 24 who are in this community. The program really is aimed at helping them complete GEDs, vocational education tracks, virtual life skills, and career readiness workshops. They also provide mentors and connection to other community resources. Ms. Ross has been working with Mr. Ware and the person in charge of that program. Their next cohort starts in April. So I'm hoping that he will get released in time to start that program. He's been in, so this time around, Judge, he's been in custody, I think it's 126 days. For purposes of resentencing, if we're doing that as well, he's done a total of 968 days on the original sentence that he's on for probation for.
968 it had been a whole bunch. It was in the high fives when he pled, and then he stayed in custody because it was something to do too. 10 do too. But you are adding to that figure the 126, or I think it's 128 now, but okay, got it.
That's correct. Otherwise, we just ask that you accept the state's recommendation in this case.
And Ladders is new, and April will be the first cohort ever, or Ladders has been going and this will be not the first cohort?
That is a great question, Judge. I know it's relatively new. I don't think this is brand new. I just looked up. I don't think it's brand new. I know it's something they've been working on getting together. It's my first referral to the program for sure, and I can send you this website if you'd like to look at it. But yes, so that is what we are hoping will help him be successful with finally completing his GED and getting a job. He was working, doing car detailing and such at a Take 5 oil change shop, Judge, but we're hoping that he will get that GED and get something more stable as well.
How frequently are there cohorts for Ladders?
I will have to ask Ms. Ross. I don't know. I should have had that squared away, but yes, I will find out, and I can get that to the court.
Okay.
Let me text her.
While she's looking that up, Ms. Smith, did you express a position on, we haven't gotten to the revocation yet, but we will, and Mr. Ware received a first offender sentence in the 23 SC case. Had you advocated you should revoke the first offender, or had you not said anything yet?
We weren't intending to ask for the first offender status.
Okay. All right. Ms. Simpson, was there anything from the probation side you wanted to add? Because I'll handle the revocation while we're working through all this.
Yeah, the judge, we were just gonna go with the discretion of the court.
Okay. All right. Mr. Ware, you want to add anything? You are free to share your thoughts. You don't have to say anything at all. But I need to give you a chance to be heard if there's something you want to say.
Not right now.
Okay. When this happened, which would have been April of last year, and you were picked up on Marasco or near Marasco, were you living over in that area or were you living somewhere else?
I wasn't living. I didn't have no exact address.
Okay, you were kind of transient. You were bouncing from place to place.
Yeah.
Okay, got it. When you are released, where are you planning on staying?
I was staying with my cousin.
Okay, is that in Fulton County or where is it?
It'd be in DeKalb.
DeKalb?
Yeah.
Have you stayed there before?
At the address?
Yeah.
Yeah, once before.
Okay. And what makes you think your cousin will be all right with you staying there?
Because I talked to him, he said that I can use the address and I'm able.
Or does Ladders provide housing?
I'm gonna interject here, Judge. So we were hoping that he could return to live with his mom again. But Ms. Ross spoke with her. That's not gonna work. I think it's a like size of the place they're living situation. So he's shared with us, he's planning to live with his cousin. Ladders does not provide housing. So if that were to fall through, Ms. Ross had informed him that our next bet would be to try to work with PAD. And she just wrote me back, by the way, Ladders starts, it's twice a year cohort starting. So, and I did send an email with the.
I saw the email. Okay, I'll check that out later. Okay,
Yeah.
you bet. All right, Mr. Ware. Well, I find there is a factual basis for your plea that this past April you were hustling in a way that if you get caught, that gets you in trouble. It was not nearly as serious as your case from 2023, which was an armed robbery. It got reduced to robbery, but that was one where you were initially looking at 10 years with no parole. But your lawyer, Ms. Wood, did a good job working with a reasonable prosecutor who agreed to let that be reduced, and so you did much less time. But then I meant to ask, what was going on in Illinois? What were you doing in Illinois?
I was doing a traveling job.
What job is that?
They would like they build concrete, put concrete inside the ground. Like it's like making pools.
Okay. And there was an opportunity to do some of that work in Illinois?
Yes.
Okay, how'd you get that job?
Through Indeed.
Okay. And did you go just to Illinois or to lots of states?
I just went to Illinois.
Okay. Well, in the future, while you're on probation, if you get work that's going to take you out of state, you need to let probation know. And maybe you did in this instance, but you need to get permission to leave Georgia. If you can document that it's for work, they'll probably give you that permission. But you need to let them know in advance, hey, I got this opportunity. I'm going to be pouring cement, making pools in Chicago or wherever it was. And as long as, like I said, you've got paperwork to show that or you can email, then they'll probably let that happen. I would hate for you to get in trouble with probation when all you're trying to do is make a legit dollar because you've got a job where you need to go to Oklahoma to pour pools or something. Okay? Yeah. All right. I find there's a factual basis for your plea. And that your plea was knowing and voluntary. Knowing means you understood what we talked about, and when you didn't, you asked questions, and I watched you do that. Voluntary means no one's forcing you into this plea, but you've decided it's the right way forward for you. Do you agree with that?
Yes, sir.
Okay. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith? Yes, Judge. And Mr. Ware, can we sign the indictment indicating your guilty plea in this marijuana case?
Yes, sir.
We'll do that. All right. Ms. Simpson, when I was looking at the 23 SC docket, it looked like maybe Mr. Ware had a couple other revocations. Is there anything in your system showing if he had any hiccups?
He had a hearing in 2024. Where he was sanctioned to complete his GED and retain his payments for his fees. But that was
That was it? So some technical violations. Okay, thank you. Mr. Ware, here's what I'm going to do in the newer case, the one that's indicted but you haven't pled to. On count one, I'm going to sentence you to 5 years to serve 1 year with the balance on probation. You're going to get credit for all the time you served. Count two is going to be 12 months to serve. It will run concurrently with count one. So I'm upping it by a little bit. Your lawyer had negotiated 8 months. I'm making it 12 months. So it's 5 years to serve 1 year with a balance on probation. And the reason why I'm going up a little bit more is I'm concerned that you got a pretty good break with this robbery case. And then we had this as well. And I need to let you know that while you're on probation, you gotta come up with something else. Life is complicated, and I know you're just trying to make money so you can put clothes on your back and food in your belly and do the things you want to do. But it's got to be because you're pouring concrete or something like that, and not what was going on in April of last year. So special condition of probation number one is that you get your GED, and you have 1 year in which to do that. Special condition number two is that you'll submit to a drug and alcohol abuse evaluation. You'll just meet with a doctor or a nurse or someone who's going to talk to you a little bit about what you put in you. And if that person recommends any treatment, then that treatment is part of your probation. But if they say, you know what, Mr. Ware doesn't have any issues in that area, then you're done with that. And then finally, I'll impose a Fourth Amendment waiver, which just means if a probation officer is wanting to know, hey, what do you got in your car? She don't need a warrant to check in your trunk, that kind of thing. That's the sentence for your new case. I'm going to revoke your first offender status and re-sentence you in the old case. We'll make sure that I get it all correct. In that old case, armed robbery is still reduced to robbery. And I'm going to sentence you on count one to 5 years to serve 3 years with a balance on probation. But you get credit for all the time you already did on that case, which was 2 years, plus the time you've been doing since then. And so you're 4 months away from doing 3 years. And you will be done with the custodial time in the 23 SC 187392 case. So count one is 5 years to serve 3 years with the balance probated. Count two still merges into count one, no sentence there. And then count three has to run consecutive to count one, has to be 5 years, and I'll probate it. So it's really a total sentence of 10 years to serve 3 years with a balance on probation, with credit for all the time you've already served. And in terms of your special conditions of probation, it'll still be no contact with Mr. Neal. That's the guy whose stuff you took. And it will be to get your GED within the first year of your probation. So you only have to get one GED, but it's a condition in both of the cases. I hope you'll participate in the latter program if that's something that makes sense for you. But you're going to decide if that's a resource that is useful for you. Ms. Smith, did you have anything else in connection with Mr. Ware's two cases? Ms. Simpson, I don't think you need to do anything because it's a resentencing of the old case. Oh, you'll send me that order, yes, but there's not a revocation order. Okay, got it. Ms. Wood, anything else on behalf of Mr. Ware?
No, Judge, thank you so much.
Mr. Ware, last thing from me, you are entering this plea very early on in the process. And so you actually have the right, if you want to exercise it, to say, no, thank you. I was willing to do the 8 months, not the 12 months. Nope, I want to go to trial. And then we'll wait and do that. The lawyer, the prosecutor will get Ms. Wood discovery. And if we need to have a motions hearing, we'll do that. And we'll get you a trial date, probably sometime this summer, if that's what you want to do. But I need to give you that opportunity to talk with Ms. Wood about the fact that she had negotiated a sentence here, and I gave you a sentence that's a little bit higher. So I'm going to have you guys talk about it. And you may tell her, look, I'm not thrilled, but I want to take this thing and get moving. Or you may say, no, thank you. Okay?
Yes, sir.
So she's going to talk with you. You can talk right there if you know what you want to do. If you want to talk in private, you guys can go back into the holding area, and then I'll wait to hear what the answer is.
All right. I'll talk to him.
Okay, she's going to head back there with you. I heard that there was some movement in the whatever unit Mr. Pennington is in, and yeah, did someone leave? And so he's going to juvenile. Are you staying here? Okay.
Oh, but I haven't heard it.
You haven't heard anything. All right, that's really what I'm getting at, is that keep Ms. Smith here. But that creates an opening in that unit, so someone's gonna have to move around. Okay. Ms. Bostic, if you want to give me whatever criminal history information you have on our afternoon case, you don't have, it may be someone else was going to cover the calendar, but it's just one case. It's going to be you if you don't want to have to come back. And you may want to come back here, but if you don't, well, let's figure out what's happening here first. But then I'd love to get that from you. All right, Ms. Wood, did you and Mr. Ware have enough time to go over his options?
Yes, Judge.
And what does Mr. Ware want to do?
He wants to move forward. He'll accept the court's sentence.
Okay. Mr. Ware, you are young. That's why I was saying, wait, 26, 22? You're 22. You got a lot of your future ahead of you. I hope you are getting kind of tired of wearing the jumpsuit and being locked up. And I hope, this is the bigger hope, is that you find some opportunities. I appreciate that life hasn't dealt you an easy hand, and I'm hopeful, whether it's through the ladder program or maybe a cousin's helping you out, that you can find some stable employment and get some money in the bank a little bit and sort of get your own situation going. You've got chances out there, and I just hope some people give you some breaks so that you head in the direction you want to head in. Okay? Good luck with things.
Yes, sir.
All right.
Thank you, Judge. I'll get this.
You're
to you in a
welcome.
minute, okay?
All right.
Ms. Nelson, do we leave this Zoom up for the afternoon?
Yes, Judge.
Okay, we'll do that. I'll mute it. No, Mr. Gordon yet. Okay.
Judge, he may be joining via Zoom.
Okay, if you could reach out to him, that would be great. Thank you. And Mr. Phillips is here. We'll wait to bring him out till we get. What's on the?
Patrol problems.
Okay, we don't need it. I just was curious what it says.
I don't know if it's
Okay, we don't need it. I just didn't know it. I could see it had some.
It's the one I couldn't.
Hmm?
I said this is the one I couldn't fix. What?
Is Miss Smith coming here or you are Miss Smith?
I am Ms. Smith.
Okay, I didn't, when you said assisting, I thought maybe you would be so you are going to handle the plea. Fantastic. Thank you for being here. So we're not waiting on anyone from the state side. We are waiting for the defense attorney. Thank you.
Sorry for the confusion.
It's all right. Hello, sir.
Good afternoon.
We are ready for you if you are ready for Mr. Phillips.
I got a phone call about an hour and a half ago that the offer has changed. That we're rescinded well, it's changed, so I have to speak with him.
Okay.
And, I'm sure I'm gonna go forward with it.
Okay, well, if we can't, we won't. We've got everyone here if we need to. But why don't you talk, this is not Miss Smith,
I'm 80 and Mandela.
right?
Mandela. So did she?
You sure? We can discuss it. You want to?
Judge, don't mind looking.
No, that's fine. Have a quick combo.
Yes. She said, I think she's stuck. It's an actual on.
Who's that?
Someone different.
Oh, okay.
We'll get it on the record.
Okay. Your Honor, if we do a plea, would you prefer me to sit up there? How do you?
I would, when Ms. Rivers is handling things remotely, I have the prosecutor sit at the witness stand, and then if we go forward, Mr. Phillips and Mr. Gordon will be right there at the podium.
Thank you.
Sure. Mr. Gordon, are we gonna go forward?
We are gonna proceed, Judge.
Okay. I'm gonna get us slowly on the record as you move your way up here. Ms. Rivers, you good to go?
Yes, I am.
Great. This is case 25 SC 005484. It's State versus Choice Phillips. Mr. Phillips is in court with his attorney, Mr. Gordon. I'm going to have our guest prosecutor state her name for the record just so that Ms. Rivers gets it into the docket. And in a moment, we'll move forward with the plea. Mr. Phillips, are you ready to go?
Yes, sir.
Okay. If you spell your name for the record, please.
It's Sonia Mandava, SOWMYA. Last name is MANDAVA.
All right, Ms. Mandava, thank you for being here. Mr. Phillips, in just a moment, Ms. Mandava is going to put you under oath, ask you a bunch of questions about your rights and the facts of the case and your situation. You'll need to answer all those questions truthfully and completely. I will hear from your lawyer, Mr. Gordon. I'll hear from you as well, and we'll see if we're going to go forward with the plea. It's important that you let me or Mr. Gordon know if you've got any questions. Will you do that?
Yes, sir.
Okay. Ms. Mandava, when you're ready.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Choice Phillips III.
Are you at this time taking or under the influence of any alcohol?
You can put your hand down now.
No, ma'am.
Drugs or medicine?
No, ma'am.
Is there any medication that you normally take that you weren't given today?
No.
How old are you and how far have you gone in school?
46, graduated high school and trade school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you're charged with the following offenses on the indictment?
Yes.
Give me 1 second, I'll read.
Oh, okay.
In the accusation, I apologize, not the indictment. In count 1, you're charged with possession of a firearm by a convicted felon. Count 2, failure to obey a stop sign. And count 3, driving without a valid license.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial.
Yes.
Have you reviewed the waiver of rights form with your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Victor Gordon, about all the facts and circumstances known to you regarding the charges in this accusation, including any potential defenses?
Yes, I have.
Do you need more time to discuss the case with your attorney?
No, I do not.
Are you satisfied with the services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this procedure?
I do, yes.
Have you reviewed the accusation in this case?
I have. Oh, you asked me? Yes.
Do you waive formal reading of the accusation?
Yes.
Do you waive any and all defects in the accusation for the purposes of this plea?
I do.
Have you been arrested on these charges?
Yes, ma'am.
And Your Honor, the state is unaware of any outstanding warrants related to these charges. Do you understand that you're entering a guilty plea to the following offenses? Count 1, possession of a firearm by a convicted felon. Count 2, failure to obey a stop sign. And count 3, driving without a valid license.
Yes, ma'am.
Do you understand that? I'm sorry, I'll give you the minimum maximums, Your Honor. I'm sorry about that. The minimum on count 1 is 1 year and a maximum is 10 years. And count 2 is 12 months. Count 3 is 12 months. Has your attorney advised you of these minimum and maximum sentences for these two charges?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 7 years, served 6 months, balance probated on count 1, 12 months.
I'm sorry, can you say that again?
7 years, served 6 months with the balance probated.
Okay.
And count 2 will be 12 months probation and count 3 will be 12 months probation. All counts to run concurrent. Would you like me to give the special conditions now?
Sure.
Okay. The special conditions of the probation will be Fourth Amendment waiver, 60 hours of community service, forfeit gun, and defensive driving course. Are you aware that the court does not have to accept the recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that if you do not accept the court's sentence, you may withdraw your plea?
Yes, ma'am.
Do you understand that you may not withdraw your guilty plea if the court orders a sentence other than your counsel's recommendation?
Yes, ma'am.
Do you understand that you have until the end of the term of court to file a motion to withdraw your guilty plea?
Yes, ma'am.
And do you understand if you choose to file a motion to withdraw your plea, the discretion to grant that motion lies within the court?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your probation?
Absolutely.
Do you understand that the general conditions of probation?
Yes.
Do you understand that if you violate any laws or conditions, the court could bring you back for a revocation, which means you could spend additional time in custody?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that if you were charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case? Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you're not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, and no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, I do.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to say them all at once, and you can answer collectively.
Yes.
The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you can't afford an attorney, the right to the presumption of innocence, which means the state must prove you're guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury would be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you chose to, and the right to appeal if convicted of these charges after trial.
Yes, ma'am.
Counselor, are you satisfied your client understands these rights they'll be waiving by pleading to these charges?
I am. Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to accusation number 25SC005484, how do you plead to count 1, possession of a firearm by a convicted felon?
Guilty.
How do you plead to count 2, a failure to obey a stop sign?
Guilty.
How do you plead to count 3, driving without a valid license?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that the discretionary appeal procedure, which is outlined in OCGA 5-6-35, must be completed within 30 days of today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
And if you are ready, Your Honor, I can give you the factual basis.
I'm ready.
Right, on May 16th, 2024, APD officer.
Hold on one second.
Ms. Mandavi, please pull the microphone down a little closer. Thank you.
You're welcome. On May 16th, 2024, APD Officer Ballard conducted a traffic stop involving a 2022 Toyota Camry driven by the defendant, Choice Phillips. The officer observed Mr. Phillips ignore a stop sign at Allen Avenue and Brookline Street in Atlanta, Georgia. The officer conducted a vehicle search after she had detected a strong odor of marijuana. The search yielded 25 grams of marijuana and a black 9mm Taurus handgun. The defendant is a convicted felon and therefore was charged with the possession of the firearm. He was not charged with the marijuana charge since it was less than an ounce. Sorry. And Your Honor, this plea was made. ADA Smith wanted me to just let you know that she had given the offer of 7 years, 6 months prior to, it was based on his GCIC, not his NCIC.
Okay. What was Mr. Gordon mentioned there might have been a change. Did it used to be lower, or this is actually what it was and you decided to go back to the original offer? What did it change to?
It was originally 7 served 6 months, and then ADA Smith had offered 10 served 3 years, balance probated. And she had agreed that if it went non-negotiated, that would be the recommendation.
Got it. Okay. So Mr. Phillips, I'm going to share with you that I asked the pretrial services folks to share your criminal history with me. They were here this morning. They needed to leave. I learned that you've been arrested at least 36 times, that you have a federal conviction, that you are or were very recently on federal probation. You have 2 felony convictions out of New Jersey. You have multiple felony convictions here in Georgia. So that's probably why the state said 6 months seems a little low now that we learn more. They learned that a little late. I'm not bound by these negotiations. I'm going to hear from Mr. Gordon now about what's been going on in your life, and I'll let you know what I'm going to do. You should know that if I sentence you to any more than Mr. Gordon asks for, you'll have the ability to withdraw your plea if you want to do that. Stay right where you are, meaning in custody, until we can sort out what a trial would look like in your case. Okay? Mr. Gordon, I would like to hear from you. Share with me what you want about your client. He's also been in and out of jail recently because we missed a court date, as in he did, because he was in custody in another jurisdiction. I know I revoked his bond and put a warrant out there. I think he just went back into jail yesterday, or at least he made landfall in our jail yesterday. And that may have been because of the warrant that I got into place. So I'd like to know what he's been up to and why you think 6 months is reasonable for someone to have a gun when he was on federal probation for weapons and ammunition offenses.
Okay, thank you, Judge.
You bet.
So let's just get this out there. He has a colorful criminal history.
He does. That's a fair description.
Which I said during the last plea that we had back in that he entered into for the aggravated assault.
Which was reduced to a misdemeanor. State reduced that one to a misdemeanor.
Correct.
Yeah.
Based on the facts of that case.
Sure.
Now, let's just say now, just focusing on the facts of this case without going this not the trial, but just in the sense that this was prior to the aggravated assault. I guess this happened a year prior. And he had a different attorney at the time. But since that time, I've learned that, I mean, of course, I've seen the body cam and such in the evidence. But then there's also, because of that charge, he was still under supervision on from his federal charges at that time. Of course, that triggered a revocation hearing to which.
Meaning this case did.
Yes. It
Okay.
triggered a revocation in federal court, to which I have obtained the transcript of where that other person that he dropped off left the vehicle, recently dropped off, recent occupant of the vehicle, left her gun under the car seat.
Okay.
Not car seat, excuse me, under the passenger seat. And so, I mean, like, while we're aware that the jury doesn't have to, you know, they determine credibility. Not
Sure,
necessarily
they could
federal judge.
decide that that's not compelling or it is compelling.
Correct.
Yeah.
But I think that he understands that he now, I mean, I'm sure he, with, like you said, 36 arrests, he knows what his responsibilities are, but it's not, you know, the carelessness he has to make, it's his responsibility, not the lady who left the gun in the car. And so I think that he understands that piece now going forward. Now, just that, I know that the aggravated assault was different, a whole different case, but when he originally got arrested on this case, he bonded out 2 months later. And then, of course, later on, he was picked up on that aggravated assault. He then, you know, that kind of messed up with his bond. I don't want to say messed up. It didn't get reinstated until 3 months later. So it wasn't that he was in custody, but for just the aggravated assault, he was also, even if he got a bond on that, he would have still been in custody because his bond was revoked. So I think that he should also get some type of credit for that time, those months that he was in custody and his bond, and until the time it was reinstated. Further, I think that even still, like, and just to address what you was just saying about him coming, you know, back into custody, he never left custody. Even from the last plea, he went over to Henry County, and he's been in Henry County since, and for the revocation.
So Mr. Phillips pled in November of last year. You're saying from there, it looks like he was released on the 23rd of November. He went from there to Henry County.
He went directly to Henry County.
Okay, and has been in Henry County until he came back here.
Yes, and so that sentence should be over the 23rd of this month. It's 4 months.
And what are the charges in Henry County?
That was in 2018, but I think it's second degree. Don't quote me on that. I can check it, but it's second degree burglary.
That was violation of probation for.
No, that was a violation. We talking about the charges itself.
Why did Mr. Phillips have to sit in the Henry County jail for the number of weeks that he did?
Probation.
Okay, violating a Henry County sentence from 2018.
Correct.
Okay. All right.
I believe he still has 7 years, so it would probably, if they transferred over to Fulton County, he'll probably be reporting to the same place for both of them.
Got it. Okay.
And just, he's been in custody continuously over a year now, though for different reasons. And I think he's ready to make a change. He has support. He has his family. His mom's always here, but I know that he's had other family members come at different times. So he has substantial ties to the community. He has adult children, and particularly he has one that's graduating college in May, which he would like to attend.
When you say he's been in for over a year, I'm just looking at the Fulton bookings. I can't see others. But Mr. Phillips went into custody in April of last year. April 18th, he went into custody, and it doesn't look like he was transferred here. So he was arrested for something on April 18th of 2025.
You're correct.
And he hasn't been out since then. So he hadn't really been a whole year. Because here we are, it's close, but I'm doing some math here to figure out what my sentence is going to look like to reflect the time he's been in. And it looks like it was April, so it's more like 10 months. That he's been. Okay, that's right. It's still a long time. 10 is pretty close to 12. I just want to make sure I wasn't missing anything.
Yes, Judge. And I also think that, with the 7 year, provided, granted, the 6 months is light, but I think that with the substantial amount of probation that he has, if he violates, he'll definitely be back in custody and before you, and he would have to answer.
Right, although we've tried that before in Henry County, I guess, because they gave him a lot of probation, and then he was back in front of them.
Well,
but I hear you.
The issue with Henry County was, it's not, the misdemeanor charge that we had that reduced it wasn't the main issue. He has a lot of restitution that I don't even know how he's going to really pay, but so I think that's just going to be an ongoing issue with Henry County.
Okay. Anything else?
And nothing further, Judge. We just ask that, that you accept, considering all the circumstances and the totality of them all, that you would consider just accepting the plea as negotiated.
Okay. Ms. Simpson, Mr. Phillips is on state probation? How many cases?
2 in Henry County and 1 here in
The one in Fulton is but maybe it's just misdemeanor probation. There's another one in Fulton? It's not the plea that we took in November.
He did this plea in March of last year.
Okay, what's that case number?
16 SC 144957.
He pled guilty to a 2016 case in 2025.
Yes.
Did you help with that, Mr. Gordon?
No, and I don't.
Before your time?
Yeah, and yes, Judge. I don't, yeah. I don't even know what the charges would
This
be.
one was before Judge Nyman.
Yeah, what did you say? 16 SC?
16 SC 144957.
957. Okay, I was going to say that you don't want to have this case.
Was it a traffic or something?
Well, I'm going to look. That's Mr. Phillips. Non-complex. Straight. It was entering auto. Theft by, it was from 2015 was the conduct. Wonder why it was hanging out for so long. He failed to appear in September of 2016, got a bench warrant, and then bench warrant got set aside in 2024, and then it just took a little while to work out. Interesting. And the final sentence was 9 years to serve 4. Those were commuted to time. So basically 5 years probation. Another gun.
I kind of want to, well, I'll wait till you finish.
I'm just looking at through. Okay, so right, that's ongoing. And you're saying 2 cases from Henry. Okay, all right.
So just while I just found out about that case, or I probably could have found it if I just looked a little harder, but again, like you said, it was from 2015. But the other thing is, I just failed to mention that in addition to the custody, I know that you don't have the honor of that time, but once he bonded out of here for this charge, before the aggravated assault and being rearrested, he still didn't get out of custody. He went over there for the revocation for that, like I said, in federal court. And so he didn't get out of there until, what is it, September of that year?
September 18th.
So he's also, I granted that was for the revocation. I just wanted to just say that he was in, custody for these charges over there as well.
Okay, got it. Mr. Phillips, anything you want to add?
I apologize to the courts. Like my lawyer said, I know that I do have, a colorful past. I've definitely learned my lesson. There's extreme unfortunate events that led to this right now, starting with that charge from last year in April. I have been incarcerated this whole time, and I've definitely learned my lesson, sir.
Okay.
I will not be back before you for violating any type of probation or any type of charges whatsoever. And I'm just really wishing that I get to see my daughter graduate college.
Well, we'll see if that happens. You have a colorful current as well. I mean, you've been pleading out the cases recently. You've had revocations recently. So I don't want to dump all this on, hey, you were 16 at the time it happened. Some of these things are old. Like the case you pled out to in March of last year was from 2015. That's old. And it may be that your New Jersey convictions are old. I didn't have dates for some of those things. And I don't mean for someone's past to continually define their future. But I also want to be clear that some of what we're working through here is fairly current. The charges you just pled guilty to involve you being around a gun and marijuana less than 2 years ago, after you had accumulated these other convictions. And so after the point where you were and you would have been 44 then. It's not like you were 17 years old. You are a mature adult. And so you lack the ability to say, well, I'm still working through growing up. You grew up a while ago. You went to trade school. You got adult kids. You got someone about to graduate from college. That's a dad who knows better. And so when he gets stuck in a situation like this, it's a look in the mirror moment. It's not a, well, but my parents didn't help me out, or my big brother was a bad role model. It's you doing you. And here we are with the 36th arrest. So, Mr. Phillips, I find there's a factual basis for your plea. I appreciate Mr. Gordon doing what he always does, which is look for a defense. And maybe it's a tribal case, but if it doesn't go well, it's certainly going to be a different outcome than right now. So I appreciate why you're pleading. I find that your plea is knowing and voluntary, meaning you understand what we're talking about. No one's forced you to plea. You agree with that?
Yes, sir.
Mr. Gordon, do you authorize someone in my office to sign the indictment on your behalf?
I do, yes.
And Ms. Mondavi, can we sign for you? And Mr. Phillips, can we electronically sign your name to the indictment?
Yes, sir.
We'll do that. All right. Ms. Simpson, I don't think that this plea is a basis to violate the probation in the 2016 case, because the conduct predates the 2016 plea, which was in 2025. All right. That's some funky timelines, but the good news for you, Mr. Phillips, is that the sole consequence, as best I can tell, is, at least for your Fulton cases, is the sentence I'm about to give you. It's not going to trigger more probation warrants. Not an issue with the Henry cases either?
That's what the basis for the revocation was.
Was this charge. So you should be in the clear, which doesn't mean you get out of jail tomorrow. You should just be in the clear that there aren't more repercussions as a result of this plea. Here's what I'm going to do. I'm going to sentence you on count 1 to 7 years to serve 1 year with a balance on probation. Counts 2 and 3 are both 12 months to serve. They will run concurrently with count 1. You get credit statutorily for all the time you've been in since your arrest in, whenever you were arrested, May in 2024. So at a minimum, it's the 262 days that you've been in Fulton County. It was a whole lot more than 6 months, which is why I'm not giving you 6 months. You also get credit for the Henry County time. I can't do that math because that's not Fulton County time. But the lawyer you've hired standing next to you can get the custodian certificate from Henry County, and you'll get credit for that as well. And we are pretty darn close to a year. Is it May release date? Is it April release date? Don't know. But you do get credit for all that time. That's a sentence that I still think is on the lighter side, given your criminal history, and in particular, the fact that here you were with a gun again. But that's where we're going to be. Special conditions are 1, a Fourth Amendment waiver, meaning that while you're on probation, if probation thinks we need to search what's in that backpack, that book bag, they can do it without a warrant. You'll need to do 60 hours of community service. You'll need to do that within the first 6 months of your probation. You'll need to complete a defensive driving course, again, within the first 6 months of your probation. The gun that was seized in this case is forfeited, and I will waive your probation supervision fees for the first 3 months while you get back on your feet and line up a legitimate job so that you are earning for you and your family. That's the sentence that I think is reasonable given all this. And I want to repeat, your lawyer can help you with the math, but you get credit for all the days you've been in custody since your arrest in this case. That is a sentence that on paper is more severe than what your lawyer asked for. I don't know that it's going to change a whole lot because of the credit you've earned for all the time you've been in. But I want to give you and Mr. Gordon a chance to talk about it because we're early enough in the process that you can say, nope, please put me on a trial calendar, and we'll get you on a trial calendar a few months down the road and see what happens with the trial. But you certainly have that right if that's what you want to do. So I want you two to talk and let me know. But before we do that, Mr. Gordon has a question.
I think it was under my understanding that while I understand it's not determined by us here with this credit for time served, that it would have to be for this charge, not just any time in confinement.
So that statute was amended recently, and there's case law applying it. And I believe that time that Mr. Phillips has been in custody since this charge is time in jail. And if a judge is saying you should do X as a result of this, and since that incident, he has done X minus 3 weeks, he only has 3 weeks left. It'll be your job to get that custodian affidavit from Henry County. But I believe it is applicable for 2 reasons. One, the statute says so, but 2, that was a revocation predicated on this conduct. So I think you'd have that argument as well, but I don't think you're going to need to make an argument. The way this statute works and the way that GDC has been applying it, as they should, because it's what the statute says, that it's time in confinement post-arrest is creditable to the person when they're sentenced.
Yeah, I've seen that. I've seen the new, but me and trying to interpret that and like, who do I go to? But I'll figure it out.
Yeah, well, who you go to is the sheriff of Henry County, because that's the custodian, that was the custodian of Mr. Phillips. And so that's the person who can generate that affidavit that says from date X, which would be November 24th until yesterday, whenever it was, he was in custody in Henry County. And you add those days to the 262, that reflects 3 different times in custody here. The first 2 days till he bonded out, 220 days when he was trying to repost bond and he had those other charges. And then there was a 42-day stint. So that's where we are. But you should talk because, like I said, Mr. Phillips gets to make this call of, yeah, that's not what I asked for. It's actually less than the 3 years, but I'll take it, versus, nope, I was ready for the 6 months, which would have punched my ticket today. Okay?
You still need to talk. Let's go talk. I think it's a thing. Do this dash. All right, I believe
Judge, we got a letter, email from our commissioner saying that, a bill has been moved to the Senate during this session that will allow, probationers who are, facing a revocation hearing to be allowed to receive credit from the date of the violation up to the revocation date.
Huh? Well, change the math that we do.
It will.
That's interesting. We'll have to follow that. So if it passes, we calculate things.
Yeah, if it passes, this, at the end of this session, it will go into effect July 1.
Yeah.
But yeah, it'll change the path.
Yeah.
Of the revocation.
Yeah, it will. And if someone didn't have a lot of time left, you could get to a point where, you know what, just gotta let you go. You've spent the time you were supposed to. Huh.
Which will also then change all the revocations when we have those older warrants.
Yep.
So that actually, I'm thinking that would clear out.
But when you say, I have to look at the bill, when you say credit from the time of the violation, if the violation was they absconded in August of 2020 and they haven't been in custody since, they're not getting credit. There's nothing they're getting credit for. It would be if they were in custody.
It didn't, I guess once, if it passes, it'll break it down more.
Mhm.
The letter that we received, it only just generally stated that the probation will receive credit from the date of the violation up to the hearing date.
Did the letter you received list the bill number? Because I'd like to look it up and learn a little bit about that.
House Bill 535.
535. Thank you.
Says, clarifies how credit return service is calculated in probation revocations that result in incarceration. The bill directs the Georgia Department to grant credit for each day of probation or expense and confinement. So maybe that does mean once we've been arrested on the warrant.
Yeah, I'm looking right now.
beginning of the day.
So what it says, it's a very short bill. Regarding any sentence imposed pursuant to a revocation of probation, a person shall be given full credit for time served for each day served in confinement since the date of the commission of the violation. It just links it to the provision I was speaking to Mr. Gordon about, this 17-10-11, which now says, in Mr. Phillips's case, he would get credit if he had been in Henry County for a shoplifting. It had nothing to do with this. If he was in jail after his arrest in this case, that jail time that's credited towards any sentence I impose. And this just puts probation on the same footing, so we don't have to worry about that. Well, but when did you actually? Yeah, and so hey, I've been in jail nonstop for the last 2 years, and that's the conduct you're revoking me for, then if I revoke you for anything less than 2 years, you've already served the time you're supposed to. And if you only had a year left on probation, then you got to get time served. That will clear things out. Yeah.
It does say for any reason. I do remember that, but I think I was a little confused with like that against the case law.
Yeah, well, and because the case law was based on the earlier version of the statute. It's reprogramming. It's good stuff.
Well, we're going to proceed.
Okay, so Mr. Phillips, you had enough time to speak with Mr. Gordon?
Yes, sir.
And you want to go forward?
Yes, sir.
Okay, we'll do that. Where are you going to be living when you get out? What county?
Fulton, my mother.
Okay, great. Thank you, Mom, for providing a roof over his head for as long as you're willing to do that. You're fortunate in that way, Mr. Phillips. So you'll be reporting to probation in Fulton County. Even though you got these Henry County cases, that's all supervised out of Fulton. Do you know where the Fulton County probation office is?
Yes, I do.
Couple blocks down the street, 48 hours after he's released? Okay, there you go. Anything else, Mr. Gordon?
Nothing further, Judge.
Appreciate your time. Ms. Mandava, anything else?
No, Judge.
All right, that's it. Good luck.
Thank you.
Happy to treat that.
Yes, sir. Thank you, Ms. Rivers.
Okay, Judge, have a good weekend. I don't think we have anything tomorrow.
Hold on one second.